2, my lord. Considering the seriousness of the matter, my lord, for non-payment of sufficient allowance for last 8 months, but simply giving me the opportunity.
56. Okay.
Maybe
56. If we are unable to complete the list, then we'll take it up.
Lots. I'll do it. Obliged.
Yeah.
May I please, Rashid? Rashid, I pay for listing of this matter. Matter related for removal of from service, and it was filed on 17th of this month.
Motion.
Sure. Any date before?
Motion will come tomorrow, day after, whenever.
Yeah.
When do you want it? Tomorrow?
Tomorrow.
Okay.
Day after tomorrow.
I know.
Day after tomorrow, motion.
Yeah, my lord, day after tomorrow.
All praise for motions allowed.
I have a prayer for Lordship. I have a prayer for listing of an IA. IA is for restoration of the petition, if possible on Wednesday.
Restoration.
Restoration.
Okay.
Lordship.
May please, Lordship, with the consent of the other side, I beg to mention item number 24, 25, and 26. Item number 24, also kindly allow us some time to file our reply.
Reply. You are for GAD.
I am for GAD.
I am for the petitioner.
Petitioner.
We have filed the affidavit.
So all three matters.
In item number 24, in others matter, we have already filed our reply.
Item 24 on the request made by the council to the petitioner, stand deferred to be listed after 3 weeks, enabling him to file the rejoinder affidavit. Since item 25 and 26 are connected with 24, let all these matters be listed again after.
I beg to mention item number 50 of today's list matter.
Yes.
I have taken the consent of the petitioner also, let the matter come after vacation.
50 on the request made by Mr. Gayon, done at CDC, matter stands deferred to be listed after 3 weeks.
There's an interim order of 18.5.
The interim order passed earlier, if any, will continue.
Master.
Item number 37, Lordship. I have taken the consent of the other side. I have to file affidavit, Lordship. Can it be after vacation, Lordship?
37. 37 on the request made by Mr. P. Sharma, standing counsel, Fisheries Department.
Yes, Lordship.
Stands deferred, to be listed after 3 weeks.
Highly obliged.
May please, your lordship. May I beg to mention item number 38 of the daily list as well.
38.
With the consent of other side, the matter must be taken up some other day.
You are mentioning on whose behalf?
Jake R. Sharma.
For the petitioner.
Yes, sir. I am for the response.
Any objections?
No, Lord.
Mr. So-and-so may makes a mention for relisting the matter after 3 weeks. Submitted that Mr. S. Royal and the CDC does not object to the prayer made. Please take order.
May I please? I beg to mention item number 48, madam. This will come up after vacation. I have taken the consent of the other side.
48 on
My
the request made by Mr. J. Mitchell stands deferred to be listed after.
My lord, interim order.
Interim order is any. Spread out. So tomorrow, but day after, no, I look. No, I look on a motion. Otherwise, Kylie can keep an answer. Yes.
Made your lordship. On last occasion, this honorable court has directed us to produce some instruction of it. I have received. Letter pertaining to compassionate appointment manner. May I read, my lord?
Yes.
With reference to the subject cited above, I am directed to inform you that the prayer petition submitted by Srimati Purnimawala Roy, who is the petitioner here, was forwarded to the district level committee DLC Kamrup Metro, as her late husband was working as Dhubri Fakirganj ferry service under IWT Division Gauhati. Lordship, may kindly note the word IWT Division Gauhati, my lord. However, the DLC Kamrup Metro did not recommend her case for compassion appointment. A copy is enclosed here with my lord. So her husband died in the year 6/10/2011, and we have placed the case of the petitioner before the DLC Kamrup Metro 4/12/2013, and her case was rejected due to dearth of vacancy. That my lord will find at the page 3. I have presented the instruction, my lord. Purnima.
Then why was it sent to SLC?
SLC sent because dearth of vacancy earlier it was for clause 15. It was for other department consideration. It was sent to the SLC earlier. So it's like that, but SLC has also rejected. So it's not a case that her case was not
Bring
placed.
it on record.
Lordship,
Bring it on record by way of
Lordship.
filing an affidavit.
my lord.
Yes, Mr.
Yeah,
Das.
Lordship, may kindly issue
Let them
notice.
file an affidavit.
Plus, my lord.
Third counsel for party issue notice within 4 weeks. MS MD Bora and study counsel.
Transport.
IW Transport Department submit that she received the instructions. Like to bring it on record. Prayer meet is allowed, district court.
Lordship, I am for 1, 3, 4, and 6.
Bora for 1, 3, 4, and 6. Mr. Ardhor for 2 and 5.
Deeply obliged, my lord.
Yes. Very good.
May we go? Application for appointment of arbitrator. Arbitration clause that number 111.
Third counsel for party issue notice written in 4 weeks.
I accept.
Mr. S.S. Roy, the LCGC appears an exception notice.
For the
Respondents, therefore notices the way extra copies be furnished within a period of 1 week from today. The respondents may file their objections if any.
if you have
Notice, Mr. Viswas.
Notice, but it is a bit slightly different, the present scenario. What has happened is, just notice will be required. But what has happened is, here, there was an arbitration clause in 3 same deeds. These agreements, on the basis of which the respondent out here had issued a notice invoking the arbitration clause, and at the same time had appointed a sole arbitrator. So we did not respond to it. Thereafter, the person who was nominated as the sole arbitrator started the proceeding without following
He was nominated by the respondents.
he was nominated by the respondents, because there is the arbitration clause merely say that if there is any dispute between the parties, it would be resolved through arbitration. There was no nominating authority, neither the procedure was prescribed. Now, the respondents, who was the landowner and we are the builders, they invoked the arbitration clause, and in that arbitration, invoking the arbitration clause, nominated a person as the sole arbitrator, and that person, on the basis of that nomination, started the proceeding. We objected to it by filing an application under 16, saying that the procedure has not been followed. And he proceeded with it. And today morning at around 2 p.m., 2 a.m., sorry, the finding has been issued by the sole arbitrator, though that he has the power, in spite of the fact that we had raised this objection, he is going to proceed.
Arbitrator has delivered the award.
No, not award. He has rejected our application under section 16. We had raised it because we have the option to file for raise the objection, but as he was not proceeding, we came before this because seeking termination of the mandate, because the procedure is totally being violated as per the law laid down, Your Lordship, because the interested party cannot nominate the arbitrator, and if at all, it would be a 3-panel arbitrator. Both parties would nominate one and they will appoint another, or both the parties
Will
agree.
issue notice for the time.
Yes, sir.
Mr. Viswas for question. Issue notice returnable 4 weeks. Steps on the respondents by speed post. In 1 week from today. You want to take Dusty also?
Yes, sir.
Dusty is also permitted, provided it is through the registry of the office. Event service by way of Dusty is undertaken. Affidavit of compliance is required to be filed. Released after 4 weeks.
Highly obliged. In this case, we have filed this contribution, levying non-compliance of order dated 16/6/2025. Basket
Mr. Monto, Leonard Counsel for Petitioner, issue notice, terminable 4 weeks. Steps on the respondents by speed post in 1 week from today.
item number 6 is also simple.
6 similar order.
Okay.
The order next one, the relevant page 20, my lord. There are 25. Period of 1 month.
Third, example of the party, you should notice for which steps on respondents by speak post within 1 week from today.
Non-form times of order dated 14/8/2025. Order is at 27 to 39, page number. Page number 39 is the operative part.
Level counsel to the petition should notice within about 4 weeks, steps on the respondents by speak post within 1 week. What do we leave out? I need the order.
It's a content petition, my lord. The violation of order dated 25/2026. Page 11 and 19.
Just a minute. I think scene 9. Side look will be permitted. Yes.
Violation of order dated 25/2026, my lord. The order is at page 9 to 11.
Nine to 11.
11. Property portion last page, man. No order has been passed in this manner.
I heard the council for the petitioner, you should notice written for weeks.
Item 13 for application number 59 of 2020.
By speed post. In 2 weeks, within 4 weeks. Yes, Mr. Chaudhary.
Wait.
Lordship, I'm on VC.
Yes, we can see that.
Grateful, Lordship.
Yes.
This matter comes up pursuant to your lordship's order of 18th March 2026, Millet, where your lordship Millet recorded the contention at paragraph 3 of your lordship says Millet, violation of 8B and 8C. And then your lordship Millet taking note of the fact that the matters are pending before the coordinate bench of this court Millet, where judgment was reserved, decided Millet to defer this writ petition if your lordships have the order of 18th March.
Yes.
My lords have that. Para 9. The learned counsel for the parties are permitted to apprise the court in respect of any such order that may be passed by the coordinate bench in the bunch of writ petitions. Now, my lord, the judgment of my Lord Justice Devashish Barua has been delivered on 1st April 2026, my lord. The judgment we have placed on record by an additional affidavit.
Okay.
That judgment holds, my lord, that the
Additional affidavit here.
yes, my lord. If your lordships have the additional affidavit of 10th April 2026.
It's not here.
Lordship, I may just also make it easy for a moment. You
Yes.
see, we'll also have to study the impact of that judgment in terms of this particular contention, because in that batch, it was the challenge to the disciplinary proceedings. Whereas here, it is a challenge on the discharge. So I need to take instructions. We'll bring a response onto this. Give us time. We'll study that part and bring it on response
Let
on
me
an
just
affidavit.
satisfy your lordship straight away, my lords. The single judge, if your lordships have the judgment, my lords, of 1st April 2026, I don't see, my lords, it's completely, my lords, it's perimeter. It applies to my case. Court holds.
But I have to still bring a response. I
You
can't
see, you have
not
read the
be-
judgment. You argued before the court. As an officer
So
of the
did
court,
you. I mean, what is
you
you
can tell the
argued?
court.
So did you, Mr. Chaudhary. This
Both
is
of
not
us,
done.
both
You
of us argue. Both
Of
of us
course.
appeared, both of us argued. We know the outcome of the matter.
Yes, so therefore
State
I'll
has
take
not challenged the
instructions. How
judgment.
can there be a
But-
matter without my taking instructions and putting it on affidavit?
Just have the judgment, my lords. But I can't drag on like this. But just have 10th April 2026 affidavit. My lords have it, my lords. It's
Uh,
running page 925, the judgment. starts.
925.
Yes.
okay. Yes,
My lords have it?
we have it.
Yes. Just have the issue, my lords, first at page 1021. And I say it with a sense of utmost responsibility that this judgment applies, my lords, from all corners, my lords, to the petitioners herein. Just have this, 1021. Points for determination, my lords have it.
This is the matter where what the report was set aside.
Yes. The report, my lords, was set aside insofar as the petitioners were concerned for violation of section 8B and 8C of the Commissions of Inquiry Act. Now,
Yes,
please-
Lordship, but there is a difference, which is what my learned friend has to point out. Here, they are discharged officers. They were under disciplinary proceedings. I
my
have to
discharge
find out.
is not my discharge is not under challenge here, my lords. Please have the prayer at page 40, my lords. My friend will just bear with me for 2 minutes, my lords. I understand my friend is in a hurry, but just give me 2 minutes.
Page,
Mr. Kohli, I request you for 2 minutes.
page.
Just have page 40, my prayer at page 40. Discharge is not under challenge. Discharge has already been set aside by the division bench, my lord.
Page 40 of
The writ.
the writ.
My prayer, my lord.
Because of that,
My lords have it?
My lord, it might not be on record, my lords. But the files will find out.
Yes.
Mandamus or other writ, order or direction be not issued, declaring, adjudging the proceedings before the Justice B.K. Sharma Commission of Inquiry relating to the affairs of APSC and culminating in the ex parte report dated 2/4/2022, containing ex parte observations, finding recommendations insofar as it concerns the petitioner herein as illegal in gross violation of the rights and safeguards conferred by section 8B and 8C of the Commissions of Inquiry Act and the fundamental rights of the petitioner guaranteed and protected under suit. And please have the prayer B, my lords. This is an additional prayer here. But there are two ladies, my lords. Some observations are made on the reputation, ex parte. Glaring case, my lords. Just have the mandamus or any other writ, order, or direction be not issued to quash, expunge, delete the observations, findings, and observations made as against the petitioner in the report of the one-man commission of inquiry headed by more particularly at pages 4. Now, my lord, please have the finding of the single judge.
Yes.
So I'm seeking time to file my response on that. I will file it.
Yes.
Yes.
Mr. Kohli, there is a sound coming.
There is some interference,
Yes,
Mr. Kohli.
Mr. Kohli's end.
Probably you're sharing the same room with someone also on the VC.
Yes, also on the VC.
Lordship, I will just address that. I'm sorry for that.
Let's just have page 1062, para 94.
1062.
Squarely covered, my lords. The above analysis would therefore show, my lords, please have that the paragraph 94,
Yes.
foot of the page, my lords. The above analysis would therefore show that the commission, while holding the inquiries, either failed to take notice of the provisions of sections 8B and 8C of the Act of 1952 or had given a clear go-by to the said provision. The reason for stating so would be apparent from a perusal of the observations made by the commission who are the petitioner in writ petition. Lordships will skip that, my lords. Now please come, my lords, to paragraph 100 at page 1068. The report, my lords, the report of 2013 and 2014 clearly show, my lords, we are concerned with the report of 2013. Clearly show that the conduct of each of the petitioners were inquired into and the observations, findings, and recommendations so made in the report touched upon the reputation of each of the petitioners prejudicially. The Supreme Court in the case of Kiran Bedi held that either clause A or B of section 8B of the Act of 1952 was retracted. The participants to the said inquiry proceedings becomes the participants enjoying special privileges as mandated under sections 8B and 8C of the Act. In the instant case, the petitioners though came within the purview, please mark, my lords, of both the clauses of 8B and 8C, but the commission deprived all the petitioners of their rights under 8B and 8C. It is therefore the opinion of the court that insofar as the first point for determination is concerned, this is answered here. The report of 2013 in connection with the competitive examination 2013, as well as the report of 2014 pertaining to the combined competitive examination 2014 are in flagrant violation of the rights of the petitioners under sections 8B and 8C of the consideration of the Act of 1952. Now, please come, my lords, to the conclusions of the learned single judgment.
Page.
Conclusion starts at 1099. My discharge is not on the challenge here, my lords. I am challenging, my lords, the report. Your lordships have, my lords. Conclusion, para
1099.
Yes.
Yes.
My lords, have at the foot of the page, my lords. Conclusions.
Yes.
The instant batch stands disposed of with the following observations. Please see, my lords. The Commission had violated the rights of the petitioners under sections 8B and 8C of the Act of 1952 while making the inquiries in respect of the Combined Competitive Examination 2013 and Combined Competitive Examination 2014, and thus the report of 2013 and report of 2014 are in violation of the mandatory provisions of sections 8B and 8C of the Act of 1952. This is the same report, my lords, which is under challenge before your lordship, my prayer at page 40. Now, my lords, please have two. The report of 2013 and 14 cannot be used against the petitioners to initiate any disciplinary proceedings against the petitioners or any prosecution against the petitioners. All findings, please mark, my lords, and or recommendations so made by the Commission in the report of 2013 and 14 touching upon, please mark, the conduct and reputation of the petitioners prejudicially cannot be used against the petitioners in any forum and are rendered non-est as it violates 8B and 8C of the Act of so, madam, squarely covered by all these findings, madam. And then three, your lordships will see, madam. The report of 2013 and 2014, subject to the observations made in clause 2 herein above, are not set aside and quashed. The report of 2013 and 14 contains various fact-finding details touching on matters of public importance, and as such findings, observations, and recommendations may aid the government of Assam.
What is the implication of this?
Para
Report,
three.
yes.
Para
Not
three.
set aside.
Para three implication is, my lords, that the Commission made certain observations, recommendations that how examinations in future is to be held and conducted. So that the court says that those are for the government to introspect and retrospect. Government can decide.
So there is no interference to that.
With that. Otherwise, my lords, the findings, recommendations, observations,
So
petition.
there's no syntax error here.
No. No,
There's no interference.
No, there is no interference insofar as, my lords, the recommendations made to the government for future to be done. But it says, my lords, the recommendations, observations, make findings against the petitioners. So, my lords, I have come here because, my lords, the court has restricted it to the petitioners. My petition is pending. I am covered by this judgment, my lords. And now, one other aspect of the report. Now, please have the report, my lords, insofar as the petitioner is concerned. That's filed, my lords, with the additional affidavit of 17th March 2026. 17th
So
March.
what was the final direction given by the coordinate bench?
Final direction, my lords, are these, my lords. These are summarized here, my lords. And then my lords, allows my read insofar as, my lords, the challenge to the report was concerned on the ground of 8B and 8C. Court said, now in view of the findings, you now do a periodic review of the suspension orders. Then it says, my lord, insofar as the departmental proceedings are concerned, either you start de novo or you amend the so-called notice, to which, my lords, now they have started de novo. So, my lords, the judgment of the single judge of 1st April 2026, my lord, has not been challenged by the state before the division bench. Rather, I have challenged, my lords, one part of the finding, if your lordships have at para 139(12). That is, my lords, the court said, my lords,
139.
at page 1104.
110.
That finding, my lords, the petitioners therein have challenged that pending before the division bench.
1104.
110.
Yes.
Mr. K. N. Chaudhary, my lords, was appearing in another batch of petitions when parallel proceedings were challenged, my lords. Please see well. The petitioners having given up the plea as regards the legality and validity of the parallel continuation of the departmental proceedings pending the criminal proceedings, it is observed that the petitioners are debarred from raising such contention in future. This finding, my lords, we have challenged before the division bench. Rest, my lords, state has accepted the judgment. Judgment is final today and operative. Now, please have the findings, my lords, insofar as the two petitioners are concerned in the report.
Yes.
That report, your lordships will find, my lords, with the additional affidavit of 17 March 26, my lords.
Yes.
My lords have it?
Here.
It starts from 273. Right, my lords?
273.
If a lordships come to 307, this is what even the single judge holds, that the one-man commission completely lost sight of 8B and 8C. Lordships have 307.
Yes.
I'm reading 5-6 lines from the bottom. Maintaining the judicial principle. Your lordships have that? maintaining the judicial discipline of odi alteram partem, all the persons with slightest of involvement in the alleged anomalies and malpractices have been provided with the opportunity of being heard by issuing notice to each one of them. So, as the court issued notice on Natural Justice Commission. So, the single judge held, my lord, that it completely lost sight of 8B and 8C, and on that ground, my lord, the writ has been allowed. Now, my lord, insofar as the petitioner in item 9 is concerned, her discussion in the report is at 443. She is, my lord, Kavita Das, Assam Police Service Officer. My lords have 443.
Yes.
Paragraph number 26.
Yes.
This is, my lords, this complete finding, my lords, is in violation of 8B and 8C. That's the High Court has given relief so far as the other petitioners are concerned. Till 448, my lords. I'll just read 448.
There was no 8B, 8B,
8B,
and
8C
8C notices were
No.
not issued.
Not given. So, my lord, at 448, your lordship saw, my lord, as in other cases, in this case also, the candidate could not furnish any plausible explanation and naturally so about the malpractices leading to the manipulated selection. Now, my lord, the petitioner in item number 10 is Sunaina Aidu, that your lordships will find at page 414.
414.
4. Serial number 19. She is a superintendent of taxes officer. And the discharge orders have been set aside by the division bench. I'm not challenging the discharge orders before this court. 414, my lords. Serial number 19. And it goes on, my lords, till page 418. Now, my lords,
What has happened to the departmental proceedings?
no, my lords, so far as departmental proceedings were concerned, these two officers were not proceeded departmentally. They were discharged in 2018. Those discharge orders, my lords, went before the single judge, Justice Bhuya, who dismissed the writ of lordship's recall and those other writs. Then, my lord, division bench of Justice interfered with, set aside the discharge order. So, and reinstated us. Thereafter, my lord, fresh discharge orders have been issued. Those discharge orders, your lordships have stated, my lord, lordships recall in 28th August 2020.
Yes. 5
order of your lordship's detailed order, where your lordship saw that, analyzed the division bench judgment and stated. Discharge order is not an issue here. Now, my lord, one other aspect, my lord, the finding of the learned commission, my lord, please come, my lord, is, and this is something, my lord, I think, my lord, it should straight away be allowed. Just have, my lord, page 776. One Dr. Mrigan Saikya is summoned, my lord, by the commission. 776.
Yes.
So it's a free for all. They come and say, my lord, just see, Dr. Saikya appeared before the commission. My lord, have that sentence, my lord.
Yes, yes.
Commission pursuant to the notice and order of 8/10/2021. Must please mark this, my lords. The only notice that was issued to the petitioner, my lords, was by the commission was on 9/2/2021. Right, my lords? So on 8/10/2021, a fresh notice is issued summoning Mrigan Saikya to come and appear before the commission. Now, please see what the Mrigan Saikya statement says, my lords. Statement of Mrigan Saikya, age 60 years, lordships have it.
Yes.
This is recorded ex parte, my lords. And I'm just taking your lordship's pick to 779. I would not, my lord, want to read this part. We'll just have that paragraph, 779. After few days, your lordships have that? After few days, the file was cleared that the notification making Sri Paul permanent APSC chairman came out and he became the permanent chairman APSC. Oath taking ceremony was held at Raj Bhavan. Paul was very close to the then governor, even to the extent of supplying vegetable, clothes and wine to his security personnel. Once he became permanent, Sri Paul tried to avoid me. I noticed a coterie was formed around him. I could notice many new faces coming in close contact. It became an easier task to meet him by outsiders at his residence at Shaktigarh, so and so. Please see, my lord, the visitors included. Please see 7 and 8, my lords. My lords, 7 and 8, my lords, are the petitioners before your lordships. Lordships have seen that?
Yes.
Now, my lords, please now come to page 781.
781.
So this is all ex parte, my lords. He has come, he said whatever he wanted. I would also like to disclose, my lords, have that sentence, 781,
Yes.
second paragraph. Mr. Kohli, you have page 781.
Yes.
Please continue. My arguments will remain the same.
I would like to disclose. I thought I have also been able to persuade you.
No, not at all. On the contrary, I will assist lordship.
I would also like to disclose that Sri Paul used to have, please mark, my lords. I don't want to read this part. Assuming, my lords, on this day, my right to reputation was impacted, my lord. The commission should have issued me a notice under 8B. Right, my lord? This is recorded, and my prayer, my lord, prayer B is for expunging, deleting, and redirecting this part, my lord, from the records of the commission. Now, please have.
Let us have a look at 8B, Commission of Inquiry Act.
Yes, my lord, it's already extracted there. If your lordships take, my lord, my petition
Commission
is.
of Inquiry.
Give a copy. Otherwise, it's my lord in a single judge's order also. Please give a copy to my lord. Monani. Page 20 of the writ also has it, my lord. My lord, sir. Persons
No,
like
we are going through 8B and 8C.
C. Yes, sir. Persons likely
Likely to be prejudiced.
prejudicially affected to be heard. If at any stage of the inquiry, the commission considers it necessary to inquire into the conduct of any person, or if is of the opinion that the reputation of any person is likely to be prejudicially affected by the inquiry, the commission shall give to that person a reasonable opportunity to have been heard in the inquiry, and please mark, and to produce evidence in his defense, provided that nothing in this section shall apply where the credit of a witness has been impeached. Now, please have 8C. Right of cross-examination and representation of legal practitioner. The appropriate government, every person referred to in section 8B, and with the permission of the commission, any other person whose evidence is recorded by the commission may cross-examine a witness other than a witness produced by him, may address the commission, and may be represented before the commission by a legal practitioner or with the permission of the commission by any other person. So, an 8B noticee has a statutory right under 8C to cross-examine it, or any other person is for someone, my lords, who is not an 8B notice. Your lordship says that. To cross-examine a witness, to address the commission, to be represented before the commission. So, my lords, what the commission does here is, my lords, your lordship, when your lordships are in the report itself, just see, my lords, the finding, the disparaging finding against the petitioners, my lords, that your lordships will find in the report, my lords, at page
8.
$786. So, based on that Mrigan Saikia's ex parte evidence recorded, my lords, above gist, my lords, have that?
Yes.
Above gist of the statement of Dr. Mrigan Saikia is the tip of the iceberg. Considering the vastness of the revelations made by him in respect of large-scale illegalities perpetrated by Sri Paul in the entire, one will have to read the entire statement of Dr. Saikia quoted above to understand the gravity of the misconduct, malpractices, fraud, which is only expected will never recur in future. Before that, my lords, please come to the previous page 785. From the statement of Dr. Saikia, my lords, have that. It is also revealed that Sri Rakesh Paul had maintained. Please mark, my lords. His disparaging findings have been recorded, my lords, on an ex parte evidence of this Mrigan Saikia. No opportunity on the 8B was given. So, but there are two parts. One is, my lords, my selection as a candidate. Second part is, my lords, Mrigan Saikia's testimony, which made disparaging, defamatory statements against the petitioners, and no notice given. Now, my lords, on this aspect, my lords, please have, my lords, first in the writ petition itself 227, because one is a learned single judge, Justice Barua, says that when Mrigan Saikia was examined, a fresh notice should again have been issued. Just at 227, my lords. This is an order of 19th February 2021. My lords, have it? Of the commission.
Yes.
Where my lords, said, read the second paragraph. Let notice be issued immediately within time limit of 15 days for written response. And that notice your lordships will find at page 228.
This is issued to whom?
To the petitioner.
To the petitioner.
Yes. So, my lords, what happened was, my lords, kindly bear with me, my lords. What happened was, commission decided to inquire into the conduct of the petitioner. So that happened, my lords, on the February of 2021. When that order is passed, the lordship saw at 227. Right, my lords? To this, a notice is issued asking for my reply. as a show cause notice. That your lordships will find, my lords, at page 229. To Kavita Das, your lordship see, my lord. This is 2nd of March 2021. Right, my lord? Then the petitioner replied, my lord, at page 231.
This is prior or after the examination of?
This is prior. Even this, my lords, Justice Barua has held that just have 231, my lords, is my reply. After that, my lords, nothing was heard from the commission. So commission did not allow me to appear before the commission. Commission did not allow me to adduce evidence and cross-examine the witnesses. Right, my lords? Now, Mrigan Saikia's testimony is of 18th October 21. Just mark that.
No, we want to understand this 229 notice.
Yes.
Is issued pursuant to what?
In the commission during the conduct of
The names figured up.
Yes. On malpractices
Against the petitioner.
against the petitioners.
So the notices were issued.
And we were asked to show cause and file a reply. That reply, my lord, we filed on 22nd.
And it does not have anything against the reply and the evidence of Dr. Saikia.
No. Because Dr. Saikia, my lord,
Because you are not aware.
he was examined. No, he was examined on 18th October 2021. Please mark that date, my lord. That date, your lordships will find at page 776, my lord, of the report. He was examined on 18th October 21. So this is even more glaring, my lord.
And when was this notice issued?
This notice was issued, my lord, on 9th
Second.
February 2021.
2nd of March.
The 2nd of March, order is 9th February.
And the examination was on?
Was on 18th of October 2021. I'm grateful for your my lord's question. And this, your lordships will find, my lord, in Justice Barua's judgment, my lords. But my lord has held, my lord, that this at 1009.
You can read it.
Yes, it further appears from the report of 2013, more particularly at pages 547 to 553, that on 30th September 21, the chairman of the commission passed an order to get the statement of Rakesh Paul by showing him the set 9 loose tabulation sheets which were recovered from his residence. Sri Dilip Kumar Baisya, Inspector of Police, Sri Bhaskar Jyoti Sharma, led by Nilanjan Deka, learned advocate for the commission, was directed by the chairman to visit the Central Jail, Gauhati, where Sri Rakesh Paul was lodged. On the basis of the said order, 3 persons interacted with Rakesh Paul. On 11/10/21, a statement was recorded of Rakesh Paul in relation to the 9-page tabulation sheets. However, Sri Rakesh Kumar Paul declined to put his signature, stating he did not want to attract the rate of so-and-so. Then let's para 18 down below. It appears from the said observation that the chairman of the commission must have made the observation in the context of 583 of the Act of 1952. Now, paragraph 20. This court also finds it relevant to take note that on 18/10/2021, the statement on oath of Dr. Mrigan Saikia was taken. The reference made herein above to the recording of the statement of Rakesh Paul on 11/10/21, the evidence of Pabitra Koibatra on 22/10/21, as well as the recording of the statement of Mrigan Saikia on 18/10/21 would show, please mark, my lords, that the evidence were recorded after the notice issued to the petitioner and the reply submitted by the petitioner. There was no information given to any of the petitioners, as would appear from the report of 2013, that when the evidence was closed. So there are 2 aspects. One, my lords, on the malpractices, I am in perimeter with, my lords, the petitioners whose writ that prayer has been granted by the learned single judge. On the second aspect, my lords, of Dr. Mrigan Saikia's testimony, the disparaging comments made against, my lords, the 2 lady officers, that again, my lords, is squarely covered by 8B2. And the judgment, my lords, your lordships have seen, my lords, Kiran Bedi's judgment says that in case reputation is affected, you have to be given a notice. And that's the single judge has relied upon. But on this disparaging aspect, my lords, I want to place a recent judgment of the Kerala High Court.
No, right now, what is your prayer?
My prayer is, my lords, that my case is squarely covered, as the lordships have recorded on the order of 18th March 2026. The lordship was awaiting the judgment of the single judge. That judgment, my lords, have been delivered on 1st April 2026. That judgment squarely covers the case of the petitioners insofar as the report of 2013 of the one-man commission of inquiry is concerned. Right, my lords? Now, the additional part which I am urging before your lordships is that this statement of Megan Saikia, the recording of the statement and the observations made by the commission, my lords, the petitioners in item 9 and 10, they are unique, my lords, because this was not part of the earlier batch.
You were not before the court.
I was not before the court. My petition came subsequently, your lordships, over awaiting the judgment in, my lords, the pending before the coordinate bench. Now that judgment has come. That judgment has said, my lord, that the report of the commission has violated the provisions of sections 8B and 8C. The report of the commission is known as illegal and not binding on the petitioners. It is restricted to the petitioners, my lord. The report of the commission, my lords, cannot be used in any proceedings before any court or forum. Those are final findings, my lords, of the single judge. So my respectful submission is, my lords, I am covered, my lords, by the judgment of 1st April 2026 passed by the coordinate bench of this court. That judgment has been accepted by the state government. They have now proceeded, my lords, to start de novo inquiry against, my lords, the petitioners in those proceedings. They have even, my lords, so far suspension orders are concerned, my lords, they have done the periodic review within 45 days as directed by the single judge. So they have having accepted the judgment, my lords. That judgment applies to me proprio vigore.
What is the stage of your inquiry now?
My inquiry is not there. I was discharged, my lords.
They are discharged officers.
There's no inquiry.
They are discharged officers.
There's a stay by the single judge, my lord. Your lordships have stayed it on 28th August. That is not before your lordship. My discharge is not before your lordship. I am before your lordship challenging the findings, the recommendations, and the observations made by the one-man commission of inquiry.
Against you.
Against me. Now, my lords, that second part, my lords, where disparaging comments are made against, my lords, anyone. The first submission is, my lords, the terms of reference of the commission was not, there was no such term for the commission to inquire into. Because in that aspect, we just have that Oman Chandi's judgment, Kerala High Court judgment.
Yes.
The former Chief Minister of Kerala. Here also was a case, my lord, where the Commission of Inquiry made disparaging remarks against Oman Chandi. That your lordships will find, my lords. Only please send a copy to Ankit.
Paragraph.
Better 35. This year, my lord, once Sarita Nair had come and deposed before the commission, my lord, by a letter. Your lordships have para 35. The position is wholly different when it comes to the letter dated 19/7/13, supposedly written by Srimati Sarita Nair and produced before the commission on 6/6/14/16. The section 8B notices issued to the petitioners were both dated 9/7/15. The allegation summed up by the commission as constituting the subject matter of the first terms of reference does not contain any reference to any allegation regarding sexual conduct of the petitioners or offering sexual gratification or obtaining favors from the government. The said aspects are not borne out from any material that was available with the commission at the time when it chose to specify the allegation and constituted the subject matter of the first terms of reference. Under the said circumstances, the petitioners are justified in contending that they were caught unaware with regard to the observations, findings, and recommendations in the report of the commission based on the contents of the aforementioned letter of 19/7/13. The contents of the letter certainly had a bearing, please mark, my lord, on the reputation of the petitioner in writ petition. This is Oman Chandi, my lord. And being so, the commission was obliged to issue a fresh notice under section 8B to the said petitioner before making any adverse observations against him based on the said letter. What the commission did instead was to send a copy of the said letter to him with a covering letter dated 14/6/16. The said action of the commission cannot be seen as satisfactory compliance with the requirements 8B, more so when the sexual content of the letter had no nexus with the terms of reference that were to inquire into. Accordingly, I am of the view that those findings, observations, and recommendations of the commission in his report that are based on the sexual content of the letter dated so-and-so and the reproduction of the contents of the letter itself is not less than 4 places in the report, have necessarily to be expunged from the report so that they are not relied upon by the government. I order accordingly. Thereafter, it goes into the privacy aspect, the Swami judgment. And please come, to paragraph 40. So even in this case, Megan Saikia comes, he deposes, it's a free for all. He speaks about the petitioners and goes out without any cross-examination. Paragraph 40. In the instant case, as a discussion of the letter and its contents was not warranted, since it did not form part of the terms of reference as expounded by the commission itself, the findings and recommendations of the commission based on the said letter, that is that Sarita Nair's letter, cannot be legally sustained. That apart, the verbatim reproduction of the letter itself, here, his testimony is ad verbatim recorded. the verbatim reproduction of the letter itself is not less than 4 places in not less than 4 places of the Commission's report, which has since been laid before the Legislative Assembly, makes it vulnerable to a discussion by the public and the media and a consequent infringement of the fundamental rights of the petitioners under Article 21 of the Constitution, both in relation to privacy as well as the right to a fair trial. While it may be true that the report of the Commission itself is not binding on the government or the petitioner, one cannot ignore the fact that the report could have on public perception of the findings and recommendations therein. It has to be borne in mind it was a retired judge of this court that constituted the one-man commission of inquiry, and hence, notwithstanding the legal position with regard to its binding nature, the public could well view the findings as legally sacrosanct. The same here, Manoj. This could in turn entail public discussions, and this has happened, Manoj. I have placed records, including in the media, based on an erroneous belief that the allegations stood proved through the inquiry that was held. The fundamental rights of the petitioners referred to above cannot be left so vulnerable to attack, as it is therefore that steps ought to be taken in place to avoid such public discussions. In view of the finding, please mark that the sexual allegations contained in the letter of 19/7/13 never formed part of the terms of reference before the Commission, and hence could not have formed the subject matter of Section 8B notice issued to the petitioner. I am of the view that to protect the fundamental rights of the petitioner under Article 21, both in relation to the right to a protection of their reputation as also the right to a fair trial, the references to the letter of 19/7, the findings on the allegations therein, and the suggestions, recommendations made by the Commission based thereon shall stand obliterated from the report of the Commission, as also the press note issued by the government. Such a course of action is warranted to prevent further infringement of the rights of the petitioner, for it cannot be an answer to a citizen complaining of a breach of his right of privacy or his right to a fair trial. The document in question and the genuineness of contents of which have not been established in legal is already in the public domain. So then the court says, remove everything. That para 43, So here also I am seeking a similar relief, They were condemned unheard, Their reputation has been slurred. Please see para 2, so 43. The observations, finding on the sexual allegations therein and the suggestions and recommendations based thereupon in the report of the Commission shall stand expunged therefrom. And if your lordships have the terms of reference of the Commission,
Yes.
that your lordships will find, at page 225 of the writ. And after that, public discussions have happened, television channel discussions have happened. My clients have been castigated. The reputation has been completely slurred, So I'm saying, I'm requesting for your lordship's order to completely redact, expunge, delete it, from all records. Please have the terms of reference, at page 225. To inquire into the allegations of anomalies and malpractices in conduct of civil services preliminary main examination, the result of which was declared on 12 May 15. To inquire into the entire process of selection of the candidates and role of chairman and other members of Assam Public Service Commission. To inquire into the system followed by Assam Public Service Commission for settling of questions for conducting various examinations, including the qualification, integrity, and competence of the question settlers, and whether the question settlers are properly trained and briefed by the Commission. To inquire further whether the Assam Public Service Commission prepares a panel of so and so. 4 is to inquire into modalities adapted by the Assam Public Service Commission for moderation. 5 is to inquire and study the system followed by the Commission. 6 to study the SOP for entry in strong rooms. 7 ascertaining the above facts to suggest measures. So, my respectful submission is, no, there was no terms of reference, and the Commission, calls Mrigan Saikia, gives him a full say. His statement is ad verbatim recorded, I pointed out, and then, thereafter the Commission makes a finding on that, on his statement. That's those findings, the testimony of Mrigan Saikia, ex-party testimony of Mrigan Saikia, in so far as, it slurs my reputation, should be expunged and deleted from the record. That's the additional prayer I'm seeking, otherwise, the first part on the anomalies of the examination, I'm fairly covered by the judgment of Justice Devasingh. I'm very grateful.
Yes, Mr. Kohli.
I have several things to say, and Lordship, I'll pray for the same indulgence of my friend. His extended 2 minutes being extended to me.
Yes.
Lordship, I have several points to raise. Let me first raise and point out that there is a huge difference in the list between what was considered by the coordinate bench of Justice Barua, Devashish Barua, and Lordships. First, the findings there are officers on whom disciplinary proceedings were continuing. The officers here, or the persons here, are discharged officers. The list is different. Now, there in that list, the Lordship has held and this court has held that you cannot rely in the disciplinary proceedings any reliance on the report in terms of 8A, and 8C we cannot be done. Now, in the findings also that my learned friend has relied upon, there is nothing related to discharged officers. So my first point is we have to study. This is the first time I'm before the court also. We have to take instructions on the applicability of that judgment in terms of a discharged officer and what our instructions would be. Hence, we need to file a reply. Point number 2. Who are the petitioners here? The petitioner here was discharged 8 years ago and is not in service. They are facing criminal trial for the cash for jobs scam from 2016, Dibrugarh and Bhangagarh police station FIRs of 16-17. Trial is ongoing. I am not in the trial. We need to take instructions. Whether the trial is relying on anything on Mrigan Saikia or not, I have no idea. 3, there is an interim prayer asking for restraining the respondents for what? The OMC, which is in public domain, for it being placed on the floor of the House of the Assembly in February 2025. So is my learned friend today going to urge that this court pass an order against the Assembly of the state of Assam that because there are disparaging comments against my clients, so this court should be persuaded to give a direction to the Assembly, to the speeches therein, to the report therein, to the report having been put on the website and been seen to media channels, on relying on Justice Debashish Barua's judgment of the coordinate bench, which dealt only with DB, which didn't deal with this aspect of so-called reputation. They are entitled to take their chances in law, file defamation, file anything they wish to do. But can an order like this be passed? I ask myself. It's a precedent that I have not heard of. Oman Chandi's case is relied upon. That is specific to a certain issue. There is no allegation of sexual conduct here or sexual favors or a reputation of a person who's a former chief minister. There's not a case of a public person who was a chief minister on whom there were such allegations, and then there was the aspect of the commission of inquiry. The facts are different.
Let me just interrupt, just to ask you, what steps are being taken against the petitioner pursuant to the inquiry report?
Lordship, this is a discharged petitioner. There are no steps by the government. The petitioner has challenged the discharge. So how can there be an interim prayer? How can there be any steps? How can I be held responsible?
Mr. Chaudhary, the only ground you are aggrieved is to get these findings expunged.
Yes. Findings
so far as you are concerned.
Findings expunged and a finding, my lords, because Justice Barua, my lords, restricted the relief only to the petitioners before the court. I am similarly situated, my lords.
No, in the petitioners before the court, before the coordinate bench.
Yes.
What were their prayers?
Their prayers was, my lords, that the report of the commission, insofar as it violates 8B and 8C of the commission, is illegal, non-honest, and not binding.
We are asking you.
Yes.
The report is being relied on to proceed departmentally against these officers?
Against those officers.
Those officers.
Yes.
Departmentally, in a sense, was there an inquiry?
Yeah, inquiry was started. Because this court is
relying on the report of the
report. Yes. Report. The court had stayed the inquiry and had stayed, my lords, the suspension order.
And set aside or.
And finally, when the judgment came, Justice Barua said, my lords, yes, my first prayer that the report of the commission has violated 8B and 8C.
Right.
So these findings cannot be, my lords, used in any court or forum. First. Secondly, Justice Barua says, my lords, insofar as the show cause notices are concerned, my lords, that part of the show cause notice which referred to the commission of inquiry report, the court said this is expunged from the show cause notice. Then Justice Barua, my lords, gave them liberty. Either you proceed with the same show cause notice after modifying it, or you start de novo. They have now started de novo proceedings against those petitioners.
Insofar as this petitioner is concerned, what steps has the department taken?
Well, insofar as this petitioner is concerned, she was discharged prior to the report. That discharge order has been set aside by the division bench. Right, my lord. They have again issued a fresh notice which has been stayed.
The challenge.
Which has been stayed by the by a Lordship's court.
And parallelly, there are criminal proceedings.
Parallelly, there are criminal proceedings. And
Yes, sir.
Justice Barua says
So-
this
so-
cannot be used
So
in any court or forum.
essentially,
Yes.
what you are asking for is expansion of the findings by the commission in the report, so far as you are concerned.
My reputation and those findings, my lord, which I read out, my lord, where they said, my lord, that I was involved in those.
That's right.
Yes. Those will have both. That, so far as the first part is concerned, I'm squarely covered by the coordinate bench judgment. Second part, my lord, is an added ground here, my lord. My friend is saying, my lord, I'm a private person, I'm not the chief minister, so I don't have any right. I'm not seeking, my lord, stay of the
That's
report.
an incorrect statement. Please, I
Just
will
now
not
you
allow
said
that.
Omen Chandi was the
Sorry,
chief
I didn't
minister.
say
He's a
that.
public
I am
official.
saying-
No, the
I didn't say
question,
that.
the aspect of whether on the basis 8B and 8C not being
Complied with by the
upon or
commission.
complied with
That's
by the
final.
commission.
Yes,
I'm
I'm covered. Now there is an edit.
whether it is necessary to, what was the order of the coordinate bench? Was it
I have
interfering?
something to urge
Yes,
before
yes.
Lordship for a moment. May I,
Just have
Lordship,
it.
because I was in the midst of my submission, one point for your
Just have it.
consideration.
We'll come back to
One
you,
point.
Mr. Kohli. We'll come back to you.
Sure,
Come
sure.
back to you.
It's not related to this, but I'll wait.
But please come, Malaj, to the operative part of the judgment at page 1099.
1099.
And Malaj, one thing, Malaj. On 18th March 2026, my learned friend is right. He's appearing for the first time today. 18th March 2026, Mr. Dipankar Nath appears before this court, Malaj. And he says, Malaj, a similar matter is pending. Let's await the outcome. The Lordship says, okay, we will await the outcome. Now my friend says this is a different matter.
Yes.
Please have conclusion,
1099.
paragraph
This is
139.
not correct. This is
One-
not correct.
No, that order records is Mr. Kohli. I'm
No,
not
no, it's not
disputing.
about
You are
order
appearing for the
record.
first
We
time.
are
No, let
waiting
us-
for the judgment.
let us
It's a
come to the
substantive hearing
findings.
today.
Let's
You
come
can't
Yes,
point
I'm
your
asking
point
for
to
it.
my colleague.
I'm asking for it. Well, please see, Malad, the instant batch of writ petition stands disposed of with the following observation and guidance. Malad, sir. Number one, the commission had violated the rights of the petitioners under sections 8B and 8C of the Act of 1952 while making the inquiries in respect of the combined competitive examination 2013 and combined competitive examination 2014. We are, my lords, in the combined competitive examination 2013. And thus, the report of 2013 and the report of 2013, please mark, are in violation of the mandatory provisions of sections 8B and 8C of the Act of 1952. Two, the report of 2013 and report of 2014 cannot be used against the petitioners, please mark, my lords, to initiate any disciplinary proceedings against the petitioners or, please mark, any prosecution against the petitioners.
So this is where
Yes.
this is where you come in.
Yes. All findings, observations, or recommendations so made by the Commission in the report of 2013 and report of 2014 touching upon the conduct and reputation of the petitioners prejudicially cannot be used against the petitioners, please mark, my lords, in any forum and are rendered non-est as it violates sections 8B and 8C of the Act of 1915. Then, my lords, that paragraph 3 which your lordships asked, my lords, there were other recommendations. In future, you do this, you do that. Court said, those are only for the lordships have it again. The report of 2013 and report of 2014, subject to the observations made in clause 2 here and above, are not set aside in quast. The reports of 2013 and 14 contains various fact-finding details touching on matters of public importance. And such findings, observations, and recommendations may aid the government of Assam to retrospect as well as introspect and take a policy decision for the future. And Malad, the respondent would be at liberty to proceed with disseminate proceeding, but these are not concerned with me. Now, Malad, today I'm an accused in a criminal case. Justice Barwa's judgment says it cannot be used in any forum, including for prosecuting the petitioner. Now, Malad, that finding which I read out, Malad, based on Regan Saika's testimony, it's completely disparaging, Malad.
I will examine that.
May I, Lordship, make two submissions?
May I say this? If your lordships want to accede to my learned friend's request and give him an opportunity, this is the matter for hearing. In the meanwhile, I am seeking that this report of the commission, insofar as it concerns the petitioners, should not be used in any forum or for any purpose. Because I'm covered
Not
by
at all, Lordship. I'm going to oppose that, and I have something to say on
then,
it.
then I'm pressing for it.
Now the question is,
Yes.
what is the basis of the prosecution against you? There is no departmental proceeding against you
No.
based on this.
No. Yes.
So you are
No, my
agreed
criminal-
by the prosecution, which
In the
is
criminal case.
criminal matter.
Yes.
What
Which
is the stage? What are the charges framed against you?
No, those charges which have been already been framed, but now what has happened is there are subsequent officers who have been charged with it later on. Those matters, because of those matters, my trial has come to a standstill today. What I'm saying today is, The judgment of,
We'll examine that. What we are saying is, the finding of the court that this is in violation of 8B, 8C, all right, the coordinate bench has rendered a finding,
Yeah.
ordinarily binding, unless on facts.
no, and the
This
state has
court
accepted this
wants
part.
to-
And the
wants
state has
to-
accepted the judgment.
Maybe the state may have accepted is a different issue.
Yes.
But to say that there's no liberty for the court to disagree with the finding on
not
the
saying,
basis
no,
of
I'm not saying,
certain-
I'm
certain-
definitely not saying that.
certain
But
findings. So
what
as
I'm
on
saying
date, as on date, we accept your submission that yes, there's a judgment of the coordinate bench.
Yeah.
Holding that this particular report is violative of 8B and 8C, therefore not to be used for any proceedings.
Yes.
Including departmental proceedings. Now, of course, Mr. Kohli would like to have his say on filing response or
Lordship.
whatever else he wants to
But
say.
I have some submissions that I want to request that they
in
are
the
recorded.
meanwhile, what I'm saying is
In the
this.
meanwhile,
There is a detailed judgment of a coordinate bench of this court. This coordinate bench of this court, my lords, have emphatically ruled that the one-man commission of inquiry
no,
has,
what we are saying is that this will require some hearing, because what you are asking for and what the coordinate bench has held is violative of 8B and 8C. If we proceed to render a order today, would it not violate the rights of the respondents?
if I'm covered by the judgment, my lords, if I'm covered by this judgment, my lords, then your lordship
Not covered,
and-
Lordship.
and-
That's my
your
argument.
and the stand of the state, and the stand of the state, that matter is
My
pending
stand
before the
of the
coordinate
state is
bench.
he is not covered.
Covered by your judgment subject to concession made by the respondents.
No, there is no
I don't
concession
need a
from our
concession.
side.
I don't need a concession from the respondent. My lord. I am straight away covered by the clear finding. The
But
lordship
we'll have to examine this matter.
Well, what I'm saying is this,
Yeah.
my lord. My case, my lords, is even more egregious. That part of litigant Sakia's statement. My lords, I have been, my reputation has been ruined. My privacy has been impacted. And your lordship saw, my lords, no notice whatsoever was given anywhere.
We'll examine that.
No, what I'm saying is this, my lords. Today, my lords, I am before a constitutional court, my lords. All I'm saying is today, this judgment, my lords, in my respectful submission, applies proprio vigore also to the petition. Your lordship will record my statement. I have stated so also. Insofar as the
Lordship
report
may
is
record his statement and Lordship may also record my submissions, because I am going to insist on my submissions to
we
come
can't
from my
go on
learned
like
friend.
this here. We can't. This is the problem.
I was in the middle of this.
On a VC. My lords have asked me to answer. I am answering, my lord. Mr. Kohli, please hold on. It doesn't look good that we are having a tutu meme in court. So,
We are
what
not
I'm
having a
saying,
tutu meme. I am only requesting that I have to also make submissions and I
Okay.
need those submissions.
okay, my lords will hear him then, my lords, then give me an opportunity.
Yes, Mr. Kohli.
I have a few submissions, Lordship, because my learned friend said 2 minutes. I've held my grounds. According to me, it shouldn't have gone that far with my learned friend without my reply being there. That's my first point. Second, those are officers on whom departmental proceedings are there. How can that be compared to a discharged officer? It has to be studied. It has to be adjudicated. 3, the report is not set aside by Justice Barua. The proceeding based on the report is set aside. How can there be a factor
But
coming
There is
in
a
there
finding that
Yes.
it shall not be
Lordship.
used. It is not and not to be
to
used.
aid those petitioners,
That's right.
to aid the people before the court, Lordship?
Right.
How can it be said to a discharged officer who's a separate footing? It has to be considered, Lordship.
The petitioners-
Do we find that?
Petitioners
Lordship,
before the coordinate bench, were they also discharge officers? No.
No, they were only in departmental proceedings.
The report
It's a
is the
huge difference. Number 2, Lordship, Justice
Yes.
Barua has not, as we said, set aside the report. He has said, don't rely on the report.
All right, that's your
Next
submission.
petitions
Okay.
will be dismissed.
Yes. Then
Lordship, next point. The report, what he's saying about Mrigan Saikia, Lordship will need to consider that this discharged person before the court is facing a criminal trial. What is the state of the trial? At what stage is it? Are these statements of Mrigan Saikia there or not? Can there be interference in the trial without there being any such adjudication on it? A redacting. Number 4, can a prayer be asked on something which is in the public domain, at least since February 2025, in terms of the assembly, in terms of being on the website, in terms of discussions? Can a prayer in the interim be granted against somebody on whom a lot of proceedings are done? And how can the state be held responsible? These are important questions, Lordship. And last, if there is to be a problem with the report, The report can be challenged in its totality. Perhaps the same bench can consider it because that bench has already considered large aspects of 8B and 8C in case of other petitioners who were not discharged. So, I mean, these are questions that have to be considered. So, I will, of course, Lordship, oppose interim prayer, interim any kind of thing. Response has to come, then Lordship may adjudicate.
How long would you require to file your response?
I think, Lordship, after the vacations, we can keep it.
You know, after the vacations, we'll still have 6 months.
Lordship,
At
not
the
6
end of the
months, not
year,
at all.
so give us a fixed date, a fixed time
I
that you
think,
want to
Lordship,
file
4
because
weeks is fair. 4 weeks
because-
is fair because I need
4
weeks,
weeks,
Lordship.
all right. 4
Yes,
weeks.
Lordship, because we will also like to see what's happening in the trial. The applicability of the
Mr.
judgment
Chaudhary.
is one.
They are entitled to
No, they are entitled to, my lord.
for
What my
filing
learned friend is saying, my lord, that
Right.
the report has been upheld by the court, my lord. Then
that will
then your
consider.
lordship will dismiss my
What
petition.
we
today itself.
propose to do
Yes.
is to give them 3 weeks to file their response. Let them file it. On the next returnable date, we'll proceed to hear the matter.
In the meanwhile, at least grant me prayer, interim prayer B, my lord, at page 43. Grant, my lord, page 43.
What is interim prayer B?
Restrain the respondent at times of influence or entity in the print or electronic media, internet from reporting and publicizing the content of this. Well, at least some protection should be given, man. Every day, man, they are going through this.
We are
audit.
doing nothing, Lordship. In any case, if it is in the public
Okay,
domain,
if my friend is not doing anything, well, very well, he should welcome an order.
Hold on, 1 minute. I have not finished my sentence. Don't interrupt it, sir, because you are trying to read into my sentence. My
This
sentence is very clear.
505 and 509 are the disparaging.
Yes.
No, but
Yes.
Lordship,
Yes.
Is it being
therefore,
reported in
Lordship,
the
that
Yes.
direction
public
will have
media?
to be
Yes.
against the media,
That
not
I have
us.
placed, my lord, in the petition. Social
Let
media,
Lordship ask any
Facebook,
direction of
everywhere, my
media.
lord, discussion.
But not us. We will not have any direction because we are not involved in a public discussion. And certainly, Lordship would need to consider if
My lord, they're
tomorrow
waiting
an
for the
assembly
state, my lord.
discussion takes place, what will happen?
I don't see this, my lord. Look at the state's attitude, my lord.
No, what about state's attitude, Mr. Chaudhary?
Once
It is
again, yeah,
also
we can't have a
crimes.
dialogue state like this. No, I'm addressing
No,
the
of course,
court.
but you can't pass
This
these
is the
comments
problem,
about
my
the
lord.
state.
Once in
The
Delhi High
state is
Court, my lord, an
entitled to
honorable judge
protect the
told
life
me
and the
that
faith of the people
we
in the
see
state.
they steal the march because they can speak.
Problem
No, I'm
has come
sorry.
from
This is not
Delhi.
about stealing the march. You're making it personal because
Problem,
you're making
if
a
at all,
What's the problem? When we are
Mr.
in
Kohli
court,
and Mr. Chaudhary, the problem, if at all, has come from Delhi.
no.
Gauhati, we don't have this problem.
Lordship is right.
So we'll propose to give you an opportunity to file your response. File it within 3 weeks, and
That's it.
we will hear the matter. And both the parties are at liberty to apprise the court on the status of the criminal proceedings. At least the charge sheet. Charge sheet should be up in the air for us to find out what are the charges based on. And then
relied material.
we'll
Lordship,
pass
we need.
orders.
This criminal proceedings
course.
are not challenged before this court. That will continue.
No,
All I'm saying
your
is-
prayer is that these criminal proceedings also were premised on the report, or a part of it at least.
No, but justice, this report came in 2022. Criminal proceedings are of the
Prior to that.
2017.
Prior to that.
Yes. Now,
Lordship, I
let's-
need to assist Lordship on something.
Again,
Please
madam.
bear in mind that the one-man commission, which was by a retired judge of this court, relied upon the material that was part of the investigation. So therefore, there has to be an aspect that has to be considered that the material which the police investigated, on which the criminal trial is premised, is also the material considered by the one-man commission to have any
We'll
finding or
examine that.
anything.
We'll examine that.
Yes, Lordship, it's critical.
And
Otherwise, that will impact the
meanwhile,
trial.
you have to ensure that, notwithstanding the findings of the report, how are you allowing them to be published in media?
Lordship, what is me
etc.?
allowing them to publish? We are not taking out a press
Well,
release.
you'll have to take
We are doing
steps.
nothing, Lordship.
You'll have to take
Lordship will give an order, my lord.
You'll have to
No,
take
Lordship,
steps.
we are not issuing
State
any
is
press
helpless.
release.
No, you'll have to take steps to ensure that it doesn't happen.
No, Lordship, I respectfully, Lordship. This is a sensitive question about Article 14 in terms of the media. If tomorrow some YouTube channel, some person watches this proceeding, does a story, how can the state be held responsible? That would be a cause of action for him to come and stand before the court. We can't have these omnibus things. Number two, what happens if tomorrow, based on these proceedings, based on somebody deciding to understand who are the petitioners, what are the findings, brings it to the notice of an honorable member of the legislature who raises this question, how can the state take action? We have to be careful, Lordship, about it.
Matter
It
is
involves
pending
Article
before the
14.
court, Mr. Kohli. We are in session of the matter.
Of course, but Lordship, the
And my lord,
state
this
is
report
not
is on their website.
No, so therefore, if Lordship
And
says,
now after
let
the
report be put on the
report has
website.
after the finding of the coordinate bench, have you taken any steps in
Lordship,
pursuance
there
to
is
the-
no direction for us to take anything. If Lordship says take the report down, we will comply with an order. But we can't unilaterally do because the report is not set aside. Please look at it from the state's perspective.
We heard Mr. Nath Chaudhary, senior advocate, assisted by MSB Chaudhary, and for the petitioner, Mr. Modi appearing senior additional AG. You are for the
No, Lordship, I'm just senior advocate
Senior
after my
advocate.
designation. Yes, Lord.
council.
And I'm
representing
assisted by, of course, Mr. Nath is there and Mr. Ankit Roy and Ms. A. Roy and Ms. N. Menon.
assisted
grateful.
by Mr. D. Nath and Mr. A. Roy, and so
N.
we are
Menon.
addressing the court through virtual mode. Pursuant to the order dated 11/5/2026. Pursuant to the order dated 18/3/2026. Notice has not been issued here,
Not yet, Lordship.
as also the 11/5/2026. Additional affidavits have been filed by the petitioner to bring on record judgment rendered by coordinate bench in WPC 1380 of 2025 and other batch of writ petitions. ID judgment and order dated
1st April.
1st of April
1st April.
2026. The learned senior counsel for the petitioner submits that this judgment, the directions in the judgment squarely covers the prayers made in the writ petition by the judgment dated so and so, passed by the coordinate bench. The court had come to a finding that the report of the one-man commission headed by Justice so and so, in response to the mandates issued by the state and constituted by the state, ID notification number so and so, the report was found to be in violation of the statutory mandate of Section 8B and 8C of the Commissions of Inquiry Act 1952, and therefore it was ordered that the findings will not be relied upon for any proceedings.
Departmental proceedings, they were, Lordship, there.
Not department or
Any
prosecution.
departmental disciplinary proceedings or any
Yes,
prosecution against the writ petitions. Stop. Learned senior counsel for the petitioner submits that the present petitioner is similarly placed and the findings of the coordinate bench squarely apply to the writ petitioner, and therefore we praise for a similar order. It is also submitted that there are interim prayers during the pendency of the writ petition, as in para A and B of the interim prayer at page 6. He therefore submits that the writ petition be allowed and the directions be issued as the petitioner is similarly situated as similarly placed as the petitioners in WPC number so and so, wherein the coordinate bench by the judgment and order dated 1/4/2026, is it 1/4/26, had passed the judgment with the following conclusions. Mr. Cody, on the other end, submits that he is still in the process of examining the judgment. He would like to complete his instructions and file necessary affidavit. He further submits that the perusal of the judgment by the coordinate bench reveals that, notwithstanding the directions being issued, the report was not interfered with by the learned coordinate bench. And so far as the petitioners before the coordinate bench were concerned, they were officers against whom departmental proceedings have been initiated. However, the coordinate bench had permitted the state to make necessary amends in the proceedings or had given them liberty to go for de novo proceedings alternatively. So Mr. Kohli submits that insofar as the present writ petitioner is concerned, she is a discharged officer and no proceedings are initiated against the writ petitioner. So under such circumstances, at this stage, Mr. Kohli submits that he be permitted to file his response and the matter be posted for hearing after the returnable date. Mr. Kohli prays for 4 weeks' time. Para. Considering the submissions made and the elaborate submissions made by the learned senior counsel, drawing the court's attention to the findings of the coordinate bench vis-a-vis the findings of the one-man commission report dated so and so, and so far as the findings of the one-man commission report in respect of the writ petitioner is concerned, learned senior counsel submits that these findings were arrived at without issuance of notice under section 8B and 8C. Section 8B and 8C mandatorily provides an opportunity to be granted to the affected persons, including the right of cross-examination. None of these steps were followed, and as a consequence thereof, these findings arrived at against the writ petitioner, which have the effect of which has affected her reputation, have been arrived at by the commission without following the prescribed provisions under section 8B and 8C of the Commissions of Inquiry Act, and therefore, as had been rightly concluded by the coordinate bench by its judgment and order dated so and so passed in WPC so and so, similar directions are called for. And since notice in the matter has not yet been issued, let notice issue, returnable 3 weeks. The respondents are permitted to complete their instructions and file necessary objections or affidavit within a period of 3 weeks. Issue notice on the interim prayer, returnable on, give us a date.
31st July, Lordship?
Sorry?
31st July? I mean, I would be physically there, but subject to what suits Lordship and my learned friend on the other side.
Yes.
Or
Mr. Chairman.
28th or 20th of July, whichever of the two. 20th, 21st, 31st, whatever works for Lordship and my learned friend. 21st is also good.
21st July.
21st is good. Yes, Lordship, I'm okay with that. My learned friend needs to file a rejoinder or...
That's for him to decide. Why are you insisting him to file a rejoinder?
don't want to
He may
file
not.
I don't want to come there, Lordship,
It's
and
on-
find that a
It's on
rejoinder is taken.
21st of July. In the event the pleadings are exchanged, the court will proceed to hear the matter and pass appropriate orders. That's it. We are issuing notice on the interim prayer. What interim benefits?
We'll file a separate reply also on that.
There's no direction.
Notice will then list it for final disposal.
There's no direction by the coordinate bench for setting aside or removal from the website.
Because this was not part of the. This is an additional ground I have here, which is even more egregious. That's why I was praying for it, Malas. The Lordship's field and Lordship will list it for final hearing. That's why I was saying, Malas. These two, here, Malas, two lady officers, Malas. Look at the observations and findings.
The Lordship just wanted Lordship to know one aspect.
We'll consider passing final orders here.
Yes, Lordship, that may be most appropriate.
Because
we are grateful for that.
Giving interim orders may lead to further.
I think, Lordship, that will be
conclusion.
appropriate, but we are in your
Unless
hands.
you want to tell us that no, these findings are presently being used against the petitioner by.
Every day.
In the
They come from respected families, man. These reports are being discussed, newspapers, portals, everywhere, and Malas, more importantly, Malas,
no, then
in their website.
No, then we'll have to. Then the only remedy for you is subject to the court coming to a conclusion that all right, we direct for removal or expansion of these findings.
If I am prima facie able to establish, my lord, the litigant Saika's statement was in October 21, notice was in February 21. And my lord, it is,
Consider
the
that.
problem is, my lord, this is in the website, and this part at least should be redacted at least for the time being.
There is no finding in
May
the
I, Lordship, just
Coordinate
submit something?
Bench's order that it should be removed from the website or should not be relied upon.
No, because this part is, this issue is not there before that coordinate bench on that reputation part. Coordinate bench says that you cannot rely upon in any proceedings, any prosecution, any forum. That's good enough.
Now, once we issue the order of expansion, if we do,
Finally.
removal from website is irrelevant. So far as these findings are concerned, if we are convinced that yes, we are passing an order for expansion, that we'll leave it.
Just one thing for your consideration, it's not an
Yes,
argument, Lordship.
yes,
Section 3, under Section 3 of the Commission of Inquiries Act, Lordship,
yes.
it has to be placed before the Parliament or the State Assembly. And therefore, in effect, once it is placed there, it goes into the public domain, which is how it gets published on the website. It is not an act to harm somebody. It is about the findings of that report. So therefore, Lordship may just bear that factor also. Of course, nothing's been passed today. I was only adding it for your knowledge.
Continue, my lord.
All right.
Very well.
Let's
Deeply obliged,
we'll hear the
Lordship.
matter on 21st.
Yes, Lordship. We'll be there on 21st to assist, Lordship.
For final hearing.
We'll try to go for a final hearing. You renew your prayer, we'll take it up for final hearing.
Interim I will not press, my lord.
Sorry?
Then I'm not pressing the interim. My lord. Will hold it.
We're issuing notice.
We'll
Otherwise,
file
we
a
will argue on
response
the
in any
matter.
case, Lordship.
We
We'll
are
file a
issuing
response.
notice, making it returnable on the same day.
Yes.
In the event the final hearing is not there, then you may like to press for your interim orders if you're otherwise instructed.
I'm grateful.
Great. Deeply obliged, Lordship.
In this item number 10 also similar orders.
Same.
Similar.
Superintendent of taxes.
Similar.
Identically placed.
Identical.
Grateful, Lordship. Deeply obliged.
The lordship have granted them 3 weeks time to file.
3 weeks, 21st. You don't file it on 20, Mr. Kohli.
No, Lordship.
We
I don't do
request you
that.
not to
I
file
don't.
it on-
No, Lordship. I don't do it because that's not fair. It's not fair to
Or
the
you
court.
want
It's
us
not
to
fair
give a
to the
date?
31st. I think we'll be able to do it, Lordship. But if you feel 31st also, we are coming to Gauhati. It's not a problem. Okay.
No, 21st. We are fixing it on 21st because
So it's
there's a
done.
prayer for interim.
We'll file you 3-4 days before that, Lordship. Rest assured.
You
I
file
assure
it
you.
well before that and serve copies on the petition.
Of course, goes without saying, Lordship.
Yes.
Grateful.
Yes.
Madam B. Sharma.
No, the report,
I have
instruction says
I have-
that one of the places that you have been transferred is the
No, it was not from my,
Preferences
no,
given.
not my preference. Madam. No doubt, I have chosen one area in Jammu and Kashmir because I'm compelled to do so because the software doesn't provide. That apart, my lord, that battalion was not chosen by me.
Huh?
That battalion specifically was not chosen by me.
Where is your preference?
I've been instructed, my lord, I had a personal audience with the DG also, Director General.
Where is the CGC, learned CGC?
Madam B. Sharma was there. My lord. Perhaps he is on legs. Man.
B. Sharma, CGC.
I'll try to get.
We'll take it up after a while. Then.
My lord.
Let her come.
All right.
Next matter. Yes.
The petitioners initially appointed as one on fixed pay, my lord, on Office of the Land Records and Survey PTC. Then my lord, petitioner service was regularized. Then my lord, notice was issued, my lord, that my petitioner's regulation was cancelled. Case 55, my lord, regulation order.
Then
Then my lord, impugn order is case 17.
17.
70.
70.
May I repeat? In pursuance of order of the Secretary, LR and DM Department, PC 5 so and so is cancelled owing to the absence of the requisite approval from SIU, like competent authority, since the required approval was not obtained prior to the issuance of the appointment orders. Appointment cannot be regularized or continued. Page 53, my lord, for a while. Page 53. Next one.
Yes.
There is an administrative approval of SIU for filling of sanction vacant was near assistant grade 3 and grade 4 under LR and DM Department BTC Kokrajhar. There is a letter on 25th May.
There is a what?
There is in my lord and
Your page 53 is not very legible. This is 25th of May.
Yes, my lord.
Hmm.
And cancellation order is my lord 27 May.
Please. You were brought, this was cancellation order.
On 27 May.
Okay, this was, you were earlier regularized.
Yes, my lord. On 25th, my lord, regularized. Page 55, that is
So
regular.
that was cancelled.
Yes.
So now you are brought back to your original post.
Yes.
You should notice here. Third council party issue. Steps on respondent number. MSB Mia appears for the BTC, MSB Bora, assisting MSB Mia, accepts notice on behalf of respondent 4, 5, 6.
4, 5, 6.
Mr. Naik appears for respondent number 2. And Mr. S. Dotto for respondent number 1. And R. Bhor for respondent number 3. The respondent, the representative, the waived extra copy will be furnished within a period of 1 week.
Obliged. Here this case is that the petitioner initially appointed under the SEBA as an assistant academic officer, and later on after the merger, the petitioner has got a promotion, and that promotion order has been challenged. That the promotion order, Lordship will find that promotion order
So you are asking for higher grade pay.
higher grade pay and fresh promotion.
And
Fresh promotion order in the light of the new rule regulation, 2024. So at the time of the promotion has been granted to me, at that time, my promotion was not due. And accordingly, at that time, the regulation was not come into the force, And
What?
only on the approval.
fresh promotion order?
That promotion order means, Lordship will find that promotion order at page 39.
39.
Yes, my lord. By this promotion order, my lord, I have been promoted to the academic officer. This promotion order has been passed on 7 January 2025 by allowing the gate pay of rupees 13,900. And thereafter, my lord, after 10 days of issuing, passing this order, my lord, the regulations come in force, my lord. Next page, my lord, at page 40, the 7th January 2025, 17th January 2025. And as per that regulation, Lordship kindly turn to page 45, my lord. Academic officer and assistant academic officer in the same grade, my lord. The new, after the formation of the Assam State School Education Board, my lord. And Lordship will find at page 45, Roman 2, my lord, grade 2, includes the cadre of academic officer, assistant academic officer. And my next promotion post is, upgrade post is senior academic officer, my lord. That has been denied, my lord.
Well, I heard counsel for parties issue notice of benefit. Respondents. You are appearing for all.
Yes, my lord. Yes.
Mr. D.K. Roy appears for all. Respondents, therefore notices of the extra copy may furnished within a period of 1 week. Yes, let them complete their instructions.
Obliged, Your Lordship.
The review petition, review or revision is there against the order of appeal.
My lord, already my lord, they terminated me, my lord, so it can be put down on the court.
There is a provision for review. We have sent so many matters. You can see one order and decide. You can file a review against the same ground.
You guys are stipulated time, Lordship,
Huh?
to dispose of the review.
When was the appeal ordered?
Appellate order, my lord, please may kindly see page 57, my lord. On 11/5/2026, my lord. And pursuant to that, my lord,
11/5/26. Then review is within 3 months, is it?
Lordship, 1 month. So Lordship, a review they can file within a 30 days.
30 days.
and thereafter subsequent deputy commissioner was terminated me, my lord. Page 65, my lord. Page 65, my lord. 35/2026, my lord. My lord, the speaking order is only either
No,
illegal,
we
my
are
lord.
asking you, there is a review.
My lord.
If you want to go for a review, because that is a forum prescribed under the regulations.
Lordship, it is 90 days.
So, and the period is 90 days. You still have time to do that. Unless you want to say that, no, that, unless you want, huh?
Appeal is 1 month.
Unless
Review
you
is
want
90
to
days.
say that there are other reasons why you don't want to go for review.
My lord, because of that, my lord, the interim order, there is a 5 grounds. All are against me, but that is not proof. My lord, without my lord proving my lord any allegation, they directed to the send the matter to the selection committee, but my termination, my appointment was terminated, my lord.
You are appointed as a,
As a Gaugura, my lord, after
Gaugura.
due process of selection,
so you go and file a review. We'll give you a protection till the review order is
my
disposed of.
my
Heard counsel both parties. Petitioner is agreed by the order dated 11/5/2026, passed by the first appellate authority, namely the Director of Land Records and Service, in an appeal preferred by the private respondent,
my lord. That's one of 6.
number 6. So petitioner was appointed as a Gaugura for Gaon Pradhan for block number 4, Niz Sutia, Salal Gaon, under Nordwar Revenue Circle, the Nagsongpur district, Biswanath Chariali. District Biswanath. In an appeal preferred by the respondent number 6, the appellate authority interfered with the appointment of the writ petition and allowed the appeal, setting aside the order dated 1/12/2022 passed by the Deputy Commissioner Biswanath, appointing the writ petitioner as a Gaon Said village. Stop. The Deputy Commissioner Biswanath was directed to take necessary action in this regard. Para. Mr. J. Hendick, learned counsel for the Revenue Department, submits that there is a provision for filing a review against an order passed by the appellate authority under
162 deal.
Regulation 162 capital D. So, under the provisions of the Regulation 162 capital D, a review may be filed within a period of 90 days from the date of receipt. 90 days from the date of the first appellate authority. So, the petitioner is therefore permitted to take steps to file the review accordingly, and till such petition is disposed of, if the petitioner will file the review within a period of 1 week from today, along with a copy of his certified copy of his order, stop, for the review being filed, the review be disposed of within a period of 60 days
26, Lord.
after filing on the review petition. Stop. Till the review is disposed of, or till the expiry of 60 days from the date of filing of the review petition, the order dated so and so interfering with the appointment of the writ petitioner passed by the first appellate authority dated 11/5/2026 shall remain stay.
Our speculate order as well as deputy commissioner order 35/2026.
As also the order passed by the deputy commissioner dated 30/05/2026. Needless to say that if the writ petitioner does not file the review petition within 1 week as permitted in this order, the interim order stands automatically vacated without further reference. Disposed MSDD Government appears for respondents 2, 3, and 4.
Can take up 10 days, madam, because of
All
Sunday.
right, 10 days.
10. Much better.
The petitioners are casual employee under Forest Department Lordship. My lords, we are paying for minimum of pay scale. Under similar circumstances, your lordship and other courts has also passed a similar order.
But this judgment has been interfered with.
Notice me, woman.
No, you do one thing, you. Is there a policy? There is a policy of the government, isn't it? So the policy is still in force. Mr. Nayak?
Yes, that will be something to be decided by the government, Lordship. But in this case, Lordship, prima facie, it appears, Lordship, earlier orders were passed by this honorable court on the basis of the judgment passed in Pendas. If Pendas is not there, it is set aside, Lordship. Definitely, there is no such, question of passing any order.
No, we are aware of that. But what we are saying is that if the policy of the government is still there.
Policy of the government was there because of Jagjit Singh Lordship. If their services cannot be regularized, as an alternative, we'll pay them the minimum pay scale. If that
They are not asking for regularization. So therefore, if that policy is there, you examine, verify, and if they're entitled.
Lordship will specify that. But in this case, Lordship will face another difficulty, Lordship. Here, all these employees are, engaged by NGOs, not by the state. That is why they are unable to place their engagement letter. You please show your engagement letter. Simple thing.
Engagement casual employee.
Lordship, where even for daily wage workers, they are NGO workers, Lordship.
NGO?
Yes.
What NGOs engage them?
No, Lordship.
Under the forest?
Under the Forest Department.
No.
They will
In that situation, let them show the engagement letter, Lordship. Simple thing, Lordship. Just show your
casual employee lordship,
No.
investment orders are not issued. Lordship, they will examine it. If they are engaged by NGO, then they will go. Ultimately, Lordship, they have to
Lordship, I
examine.
kindly see page 18. Lordship.
Ultimately, they have to examine.
Page 18.
They will verify the records.
From various clubs, societies, and NGOs.
No,
No, they are not engaged by the
State.
NGOs.
They were engaged by, they are working under a NGO, Lordship. We are paying to the NGOs, not directly to the employees.
no. They were initially under NGOs and clubs, etc. And subsequently, they were.
But this certificate has been given subsequently by the forest range officer.
Voluntary casual worker.
Voluntary casual worker.
So that is the difficulty, Lordship. Earlier, the number
What
was.
is a voluntary casual worker?
Yes.
Why not? They have used the term voluntary
No.
casual worker.
Lordship, at some stage, Lordship, we have to be little strict, Lordship, because the number is increasing day by day. Every day, Lordship will face, in this petition also, Lordship is saying
Exactly
29 petitions.
Exactly on similar circumstances, other petitions were disposed of And the direction was given to verify
And all from
after
BTC again.
verification
All from BTC.
with the same, exactly with the same situation. I have also filed a lordship another 2 writ petitions that writ petitions were earlier disposed.
Well, let us issue notice, not like this. What is the meaning of voluntary casual worker? Voluntary means voluntary. You are not
No, lordship,
entitled to anything.
they have used that word ultimately lordship.
So let them answer that. What is the meaning of voluntary? I heard learned counsel for participation. Mr. Nayak.
In this matter, I am appearing for the state.
Appearing for the state. State would be number 1 and 3.
Including forest and finance laws.
So 1 and 3.
1 and 3.
1, 2 and 3. 1, 2 and 3.
Yes.
1, 2 and 3. And MS Bora appears for 4 to 9. 4 to 9.
Yes.
The respondents are represented, notices are waived, extra copies be furnished within a period of 1 week. Okay. Let the respondents complete their instructions and file necessary affidavit if so advised. Released after the returnable date.
Okay.
Yes.
Wait, Mr. relates to the winter pension, the pensioners case is above carry. So when what charging will.
Notice at this stage.
Yes. Connected case has been fixed by Russell on 23rd of July.
23rd of July. 23rd of July.
Mine.
Heard the council for party issued notice in terms of Mr. Eko, petition lady appears and accepts on behalf of all the respondents, 1, 2, 3, 4. Mr. Nayak appears for respondent number 5. Since the respondent is represented, this is a way extra copies are furnished in the period of 1 week.
I never counter
Is submitted by the council with the petitioner that a similar petition is fixed on 23rd of July.
Fine.
Paying WPC number. Similar writ petitions are fixed in 23rd of July. Accordingly, this writ petition be made returnable on 23rd of July.
Item 21 also same.
21. All right.
Public.
Similar orders 21.
Obliging.
17.
Yes.
But the matter relates to my lord, the wrong fixation of the gratuity amount.
Notice
Notice
the third council for parties issued notice returnable week. Steps on the respondents by speed post within 1 week from today. Matter be listed after the returnable date.
Victor.
Legal lawsuit. A by law petitioner has stated that he was appointed as constable, being constable number 427 under 15 APIR, Petilent Illegal Corimos 1/8/2018, and he has rendered his service duties with utmost sincerity, discipline, and to satisfaction of the higher authority.
Notice heard Mr. Dedas, petitioner, Mr. P. Soike,
For only
appearing for all the respondents. Since the respondents are represented, notices of waived, extra copies be furnished within a period of 1 week. List after the returnable date.
This case is connected to item 57, supply list.
57.
Yes, 57 is primarily, that is the main case. I request your lordship to take up 57 first.
Where is the health? Is for the health.
Mr. Gogoi appeared last.
All right, we'll take it up
Mal.
along with 57.
Mal.
Along with 57.
It's non-payment of the minimum pay scale.
We'll issue notice here.
But let the notice go, and
Third, and accounting to party issue notice. And MS P. Bora appears for.
Respond number 4 to 8.
4 to 8. Then who's for 1, 2,
1 and 2, not S.
1 and 2, Mr. S. Sharma. And finance, MS so appears for N Hazarega for respondent number 3, since the respondents are represented, notices are waived, etc. will be furnished within
during the pendency of the repetition may not be performed. Claim of the
Hmm?
during the pendency of the repetition,
What?
there is may not be barred to consider
Not,
the claim of
not like that.
Madam,
We are issuing notice, let it be there.
Madam, because the PTC authority is taking the initiative.
So you bring it the moment it
Only
is
for
done, you
this
bring it
notice
before the
document.
court.
Worship, let me obtain instruction.
Let them obtain instruction.
And fix the date after the issue.
After returnable date, you make a mention on the returnable date if it is not listed. Okay.
Only under the deadline, my lord, maybe may not be.
What is the stage? Because what is the stage? Why do you want this line from the court?
But because PTC authority is taking initiative. to
Taking
consider
initiative, so
the-
let them get the
consider
instructions. Let
the
them
last-
get the
yes,
instructions.
If he's entitled, my lord, he will get. Thanks.
Again, these are the leftover schedule of government. Again, this will be left.
You get instructions by 17th. Make it returnable by 17th July.
I'll let you. May I please your lordship? My lord, in this case, what happened? Lordship was pleased to pass an order by giving protection. Page, my lord, 77, my lord, the order passed by your lordship. My lord. And the departmental authority was directed to pass an appropriate order, my lord, considering the representation, my lord. The interim order, lordship, is page, my lord, 82. There, my lord, fails to appreciate the fact that the petitioner is a disabled person, locomotor disabled, my lord. Secondly, my lord, the ECI guideline, which provides for the fact that, my lord, if the person is engaged as a sector officer, he is not covered under the, my lord, election commission transfer. This is also the second ground, my lord. Third ground, my lord, the government of Assam has issued a notification to the effect that, my lord, the person who are working less than 3 years, they are not subjected to be transferred. Only with they can be transferred only with the approval of the chief minister, my lord. That also not, my lord. My lord,
How do you know?
my lord.
How do you know that that approval
from
was not
from
obtained?
the order, my lord?
Order may not be reflected. It's not necessary to be reflected in the order. It could be there in the file.
But within 3 years, my lord, they cannot transfer. They have to give the reason for such transfer, my lord. Lordship, kindly see the policy, my lord. Page 85, my lord. Page 85.
85.
Yes, my lord. All departments are therefore advised to ensure that no officer is transferred without completing 3 years in particular place of posting unless he is on promotion. In case circumstances require the transfer of any officer before 3 years in the exigency of the public service for other reasons, the approval of the Honorable Chief Minister invariably be obtained before such transfer. Then, my lord, before that also, my lord, top of the undersigned is directed to refer to the office memorandum dated so and so, wherein it was laid down there categorically that whenever public interest demands, an officer be transferred from one place to the off posting before completion of normal tenure of 3 years in particular,
post place, proper justification with credible ground be adduced in writing for such transfer, and order effecting such transfer shall be issued only after securing the approval of the Chief Minister. Here, my lord, they have not said anything. My lord, petitioner, my lord, under the disability, they right to disability act 2016. My lord, they cannot transfer a person from a distant place to a distant place. He was transferred from Silchar to my lord Dubli. And in complete violation of the my lord election commission guidelines. This is not a routine transfer, my lord. He was transferred at the instance of the election commission. Election commission says no. These persons are not covered. Their cases should be placed before the my lord, the concerned authority for a fresh consideration. Accordingly, my lord, representation filed, fresh consideration was made. This order was done. In similar case, lordship was pleased to pass this order.
How is this order relevant here?
My lord, the ECI guidelines saying here, my lord.
The ECI, they have not sent you out on the ECI. Impugned order 82 says that there are no guidelines framed by the state
My lord, if that be so, my lord,
to exempt persons with disability.
my lord, if that be so, my lord, then the 2009 notification will come.
So let him get instruction
Got
here. He'll issue notice on the interim prayer.
My lord, otherwise, my lord, it will be
You
infectious.
show us something that
My lord,
we are able to give you an interim order.
yes, my lord. Page 85.
85.
Yes, my lord. This is the state.
Does it say that this must be reflected in the transfer order?
Yes, my lord.
Where?
Yes. So, first paragraph, my lord.
Hmm.
Proper justification with last two lines, my lord. Proper justification with credible ground be adduced in writing for such transfer if within 3 years, my lord.
So where is it to be reflected?
In the order, my lord.
In the order?
Yes.
Doesn't say so in the notification.
My lord,
It doesn't say it must be reflected in the order. Deduced in writing. In the file which is moved for your transfer.
in writing, my lord, that is said.
Of course, in the file which is moved for your transfer. Doesn't say that it has to be reflected in the order. Reflection in the order would have been
My lord,
good.
writing means, my lord,
Writing means writing.
writing in the, my lord, order, my lord, that should be.
No, that is
for
an
this ground
that is your interpretation. But the justification will be on the basis of the file movement.
Lordship.
So it will be there in the note.
My lord, lordship may call for the record, my lord, and fix it, my lord, immediately after vacation, my lord, with protection, my lord.
No protection.
My lord, otherwise, my lord, he's a locomotive, my lord.
You tell us on this ground that you are entitled to a protection under this Disability Act.
Yes.
Lead us to the relevant
On
provision.
that, my lord, on that, and section 20, my lord.
Rights of disability.
Yes,
Person with
2016.
Who's for the disability department here? Persons with disability under which department? Social welfare. Who represents? RM Das. Where is Mr. RM Das? Mr. Dhor.
Section 20.
You will assist the court in finding out what notifications are available in respect of disability, persons with disability.
On the last occasion.
From the department. Yes.
On the last occasion, my lord, this instruction was sought for. And on that occasion, the instruction is that, my lord, they are following the Government of India notification, my lord.
Where have they stated?
I have not stated, but I have annexed the government of India notification.
That you have stated, but they have distinguished here saying that transfer and posting is also no specific guidelines or instructions by the government of Assam.
Yes, there is.
Yes, my lord. But under the act, my lord, they are supposed to comply with the my lord.
Hmm?
So, lordship, kindly say section 20, my lord.
20.
Section 20.
Yes.
Subsection 2. Every government establishment shall provide reasonable accommodation and appropriate barrier-free and conducive environment to employees with disability. Next subsection, clause, subsection 5. The appropriate government may frame policies for posting and transfer of employees with disability. But they have not issued any notification as on date. So barrier-free, my lord, accommodation. He is transferred from one corner to the last corner, from Silchar to. There are other posts. I'm not opposing transfer, but they can accommodate me in any district in Barak Valley also. From Dhubri to Barak, my lord, he was transferred from Silchar to Dhubri.
This will require instructions, Mr.
Lordship,
Chaudhary.
lordship.
When can you get your instructions here?
Immediately.
This transfer order will make it subject to the outcome of the requisition. That's all we can do. Unless you prima facie show us that this is violative of some notification rule, section.
Or my lord, subsection 2. My lord, barrier free. They can accommodate me in any place in Barak Valley.
No, they can accommodate you is one thing, but what is the event of not having policies for transfer and posting? What difficulties you face, how it is to be relied upon. Therefore, we wanted to find out the concerned department, which is what is that department? Social Justice and Empowerment.
Day after tomorrow, my lord, they can have the instruction.
Day after tomorrow, it's not possible. Can you get instructions by Wednesday?
Yeah, I pay immediately after application. On 15th of October. Ready open.
Well, then we call for Mr. R.M. Das, Standing Counsel. We'll take it up the second half. Please inform me. Yes.
The petitioner is serving as a sub inspector in the Lordship ITB. And he was even granted promotion, Lordship. I downloaded it 13 April, Lordship, 13/4/2026 at page 50. But even after the order of promotion was granted to post of the inspector, Lordship, he has not been given the charge or given allowed to assume the charge, Lordship. Then he represented before the authority. They didn't reply. Now, Lordship, after Lordship, on 15/6, page 58, on 15/6, they have said that one, Lordship, they are contemplating for a GFs, General Force Court, against the petitioner and on another person. Now, the question is, Lordship, when the promotion order is issued, Honorable Supreme Court has always, Lordship, reiterated in the KV Janagiri case also, in our High Court also, is that when the Lordship promotion order has been given, then thereafter, Lordship, any contemplation, that cannot, Lordship, bar a person to be given promotion, Lordship. So he has not been just allowed to, Lordship, assume the such thing now. Lordship may come to page, even his clearance is also there, page 25. Every clearance was there. The departmental DPC, Lordship, they have perused everything, examined everything. Thereafter, they have given me the Lordship promotion.
Where is the order of promotion?
Promotion order is at page 50. Lordship, dated 13/4/2026.
Yes.
Based on the recommendations of the Departmental Promotion Committee 2026, in the Director General ITBP Force, the following sub-inspectors CM are promoted to the post of inspector CM. The pay matrix level so and so per month with immediate effect as per the seniority as per the available category wise vacancies. Provided the person fulfill the following eligibility conditions, promotions. The current medical category should be shape 1. No major punishment has been awarded in the last 5 years. No minor punishment awarded last 1 year. No departmental inquiry vigilance cases pending contemplated against him. His integrity should be beyond doubt. Must have passed the so and so. And his name is at serial number 2. Now Lordship may come turn to page 25. Lordship, in bold letters. Lordship got it, the bold letters. It is departmental inquiry / vigilance integrity certificate given in his name, Lordship. No, stretching. Double no is stretching. No departmental inquiry, vigilance case is pending or contemplated against the above individual, and integrity is beyond doubt. Thereafter, the DPC Lordship considered everything. He was given granted promotion. He represented. Number of times represented, they didn't say anything. Now, Lordship, they come up with that order at page 58. My humble submission is that
58, what is the order?
yes, 58, that they are contemplating to Lordship start a GFC, General Fort Post against me and on another person.
So you are promoted where?
I was promoted to Lordship Inspector, to the rank of Inspector.
Where are you posted?
At Lordship Tezpur.
Tezpur.
Lordship.
Your promotional post is in Tezpur only.
Tezpur only, Lordship. After visions, they everything.
Yes.
How can they do it?
Lordship, notices may go, your Lordship will take our instruction.
In the meantime,
Mr. Ria Tobildar, Learned Counsel. Yes.
M.
So-
Burman on behalf of.
appears on behalf of Mr. MSA Guy, Learned CGC. Petitioner is aggrieved that in spite of a specific order of promotion being granted in favor of the writ petitioner by order dated
13/4/2026.
page number
Page number 50.
50,
Lordship.
dated 13/4/2026. The petitioner has not been permitted to assume charge of the post of inspector
Inspector.
to which he was promoted.
Lordship.
So, it is the submission of the counsel of the petitioner that he submitted representations before the authority by the representation dated 27/5/2026.
And prior to that also.
And
And prior to that also.
but that is the only representation available.
Yes.
But no response was forthcoming from the respondents. Thereafter, by order dated 15/6/2026, an order has been circulated where the competent authority, namely the Inspector General, Eastern Frontier Headquarters, ITBP Lucknow, as the convening officer, has convened a general force court
Against one
against the petitioner.
and another person.
And who's the petitioner?
Petitioner is Lordship, the Chandrasekhar Joshi.
Huh?
Chandrasekhar Joshi. In his-
Chandrasekhar Joshi.
Joshi.
Where are the names mentioned
Yeah,
here?
at the top first line regarding GFC trial against Lordship got it, the first line of
Okay. This order, this constitution of the General Force Court is in respect of the writ petitioner and another person whose names are reflected in the order. So it is submitted that as on date, there is no order passed by the General Force Court. However, the order passed by the disciplinary authority, order passed by the DPC, has also not been recalled, and the same, however, the same has not been implemented by permitting the writ petitioner to assume charge in the post in which he is promoted. You are placing some judgment.
Lordship.
What is this?
Our High Court judgment, Lordship, date 2013.
No, this is Supreme Court judgment. Okay,
Yes.
there is a High
Supreme Court
judgment.
judgment, our High Court upheld that, then Supreme Court also upheld it. 2013, 4 SCC 161. Lordship. Here also, please, paragraph Lordship, 13, 14, then 13 onward.
What is the judgment for? What proposition?
That even when there is no charge sheet, nothing, when promotion has been given. Even you cannot put it in the seal cover also. And in my case, it is question of seal cover does not arise. I have been already promoted.
Is there anything under the rules? Rules?
A guideline, the DOPT guideline is there. It has been mentioned here in the guide document itself. Paragraph in paragraph of judgment 164, page number 164 of the is quoted. And Lordship, the landmark judgment is Lordship placing of the on the same line, Lordship.
No, we are asking you in your case,
Yes.
are there any OMs, are there any
Yes,
rules
same.
which say that?
Yes, that is the yes.
Yes.
2012 Lordship OM order.
Can you get your instructions day after tomorrow?
Lordship, immediately after vacation.
No, immediately after vacation will permit you, but in which case you will have to permit him to assume office
Day after.
day after tomorrow. Let them obtain the instructions.
Lordship, Lordship, my
We want to know if there is any circular or rules
yes, this
to
is
the contrary.
Yes, it is contrary. No,
What
there is no-
circular? What circular is this?
Three conditions are maintained. Lordship, where Lordship the only seal cover that can be maintained. The three conditions are not found. In my
You
case,
get your instructions day after tomorrow.
but Lordship, in them, Lordship, or Lordship may be allowed to assume the trust and that subject to the outcome
No,
of the
no, day after tomorrow.
day after.
Day after tomorrow.
Lordship, if they have
Get
got
your
any
instructions.
yes.
Tell us what grounds you are not allowing him to assume office. We'll pass this.
Lordship.
The learned CBC is permitted to obtain instructions as to whether there are any restrictions, restraint in terms of any office memorandum, notification, or the rules governing the services for permitting the petitioner to assume his office pursuant to the promotion order.
That is 13-426.
The face of the constitution of the GFC, General Force Court,
Subsequent to the
subsequent to the order of promotion. Released day after tomorrow, that is the 22nd,
not
Ec-
24.
24th.
This 22nd.
Sorry. 24th. 24th of July, June, and you serve copies, extra copies today itself.
No. Apply.
But although notice was served upon the respondents, none has appeared. We take justice and steps also, my lord.
Mr. Khatunier submits for the petitioner submits that you'd like to take steps by way of dusting.
No, madam. We have taken justice.
You have taken
Yes,
dusting.
madam. In spite of that, none has appeared, madam.
Which office is this?
Forest, madam.
Forest. Who's for the forest department? Call for the forest department council.
Yes, madam. Madam, take it up as something I will inform.
2 p.m.
Yes, madam. Obliged, madam.
Yeah, please. On the last day, learned sole arbitrator was appointed. The declaration has been filed by the arbitrator.
Third, counsel for parties in deference to the earlier order dated 12/6/2026. Sri Mrinmoy Kumar Bhattacharya, retired district and session judge, was appointed as a sole arbitrator, subject to the written declaration being furnished under Section 12(1) of the Arbitration and Conciliation Act 1996. The written declaration by the learned arbitrator has been furnished by communication dated 17/6/2026, where he expresses no difficulty or hardship in acting as sole arbitrator to decide the disputes arising by and between the parties. In the event the court passes necessary orders. Considering the written declaration submitted by the prospective arbitrator, this court confirms the appointment of Sri Mrinmoy Kumar Bhattacharya, retired district and session judge, to act as a sole arbitrator, and who was appointed as a prospective arbitrator by order dated 12/6/2026. So, copy of this order be furnished by the registry to the learned arbitrator. Parties are also at liberty to furnish a copy of this order. Parties will appear before the learned arbitrator on
The third week of July.
Wait, third week. Wait,
Second week. Second week.
Definitely.
11th July. Before the arbitrator. This post.
I'm great.
Objection filed?
Yes. Yes.
Yes. What objections have you raised?
My lord, since the my lord claim sought to be arbitrated, my lord, but is especially my lord dead claim can barred by limitation money. So my lord, these applications with my lord.
Right, the objections have been filed by the respondent. Matter be listed for hearing on 23rd July.
Right.
Here I'm appearing for 1 and 2. Only filing an affidavit, madam.
Mr. M.K. Sharma for the petitioner, Mr. R. Dhod, Learned Stay Counsel appears for respondents 1 and 2. He submits that he has received instructions in the matter and you'd like to file this affidavit. Remit is allowed. Release this matter again after 3 weeks. Yes.
By this explication, correction of order of a typographical mistake offered in the order in page number 9. Page number 9.
Page number 9. Yes.
Second para, fifth line. Then measuring 1 bigger forward by pattern number 64. Arg number 144. Instead of 144, it is to be 114.
114.
Yeah, this is the typographical mistake.
And this is the only one.
Yes.
This is the only typographical.
Yes.
Yes, Mr. Bora. Third counsel for parties. Its IA has been filed seeking correction in the order dated 18/11/2024, passed in WPC 5974 of 2024. By this order, the writ petition stood disposed of. with the following order. The order which recorded. In para 2, the land, the description of the land was specified as plot of land covered of measuring 1 biga by patta number 64, dag number 144, situated at village Purwagaon under Moza Holesor, Tezpur Revenue Circle, district of Sonitpur, Tezpur. So submitted that instead of tag number 144, it should have been 114. Learned Council submits that it is this error which has occurred. Typographical error is required to be corrected. In your writ petition, you mentioned it as
114.
114, page number.
I think page number 4. Para 2. Third line.
Learned Council for the petitioner submits that in the writ petition also it is specifically mentioned that tag number is 114. However, because of typographical error, the tag number was reflected as 144 instead of 114. Stop. Para. Mr. D. Bora does not object to the prayer bit. Accordingly, this I stands allowed. The tag number description of the land will be read as land measuring 1 biga covered by patta number 64, tag number 114 instead of tag number 144 as mentioned in the order dated 18/11/2024, and the land is situated at village Purwagaon, Moza Holesor, Tezpur Revenue Circle in the district of Sonitpur, Tezpur. I accordingly stands allowed disposed of. This order passed today in the I shall be read together with the order dated so passed in WPC so. Disposed.
Deeply obvious.
I can see on Lordship. Lordship, can you pass over for timing?
This IA notice may be issued to Lordship in the IA. I have to file objection to this IA.
We'll issue notice here in the IA.
Lordship.
Third Council party issue notice. Returnable 4 weeks. Mr. S.S. Roy, learned CGC, appears on behalf of respondents 1, 2, 3, 4, 5.
5. 6, 7, they have 6 steps.
Steps on opposite party number 6 and 7 by speed post within 1 week from today. Matter be listed after the return of date. Extra copies will be laggy.
Here, please, Your Lordship. This application is filed for amendment of the writ petition number 3188/2025. In this writ petition, in the 12th line of the paragraph 4 at annexure 3, page 28, compassionate appointment to a grade 4 post. It should be grade 3 post.
We'll issue notice today, right? Issue notice. Still. Huh? So which I are you pressing? IA number? What is the IA number?
IA number 630/2026.
630. 630 has been withdrawn.
Withdrawn. to file a fresh
So
IA.
what is the fresh IA number?
I think 2047 has been
2047.
listed in the cause list.
Third counsel for the applicant, issue notice, Mr. CKS Boro appears for respondent number one,
Not two, two is revenue department. One, three,
3,
four,
4,
five, and sub-register will be revenue department.
5. This for revenue department, Mr. J.
J&D.
For number 2 and
6.
6. Since the respondent, the representative notices waived, extra copies be furnished within a period of 1 week from today. Respondent may file their objections if any. Yes.
Please, Your Lordship, kindly pass over the matter for time being, Lordship.
What is the matter about?
They have filed this IA for substitution, Lordship. And we have not received any copy yet.
You serve copies to the respondent, let it be listed. We'll issue notice here. So party issue notice. Return about 3 weeks. You are representing insurance company.
Yes, Lordship, 1 to 3.
Your name?
Ms. K. Bora.
MSK Bora appears for respondent. However, extra copies be furnished within a period of 1 week from today. Respondents may file their objections if any. In the meantime.
Up next.
My lord, here, I need some time, my lord. Instructions written.
Instructions are awaited as per the submission made by Mr. Rathod. Mr. S. Islam appears for the petitioner, released immediately after reopening the court.
It's a date here.
17th July.
7. Obligation.
It's from 17.
We have one of the petitioner is not before a lordship or seeking minimum scale of pay. But petitioner here was appointed as grateful employee in the office of CDPO, Cooperative SDS Project on 28/4/2000 and in 1995. Since then, he's continuing to serve. He has served for more than 30 years. Now, in between, the Rupendra's judgment came, and relying on Jagjit Singh case, Honorable Division Bench was used to direct the response to pay minimum scale of pay. Then thereafter, this notification annexes 5, annexes F is 24 notification came 3/10/2019. Just claiming the benefit of this.
So the minimum scale of pay was in terms of the judgment of Upendas.
Yes,
Upendas has been interfered with.
No, but that judgment, the direction was in terms of the judgment passing Jagjit Singh. Lordship, may kindly come to para 22 of Upendas case. May I present it now?
No.
May I read it?
The direction in Upendas
Yes.
is on the submissions made by the state.
Minor.
State has come up with their notifications.
Minor.
Where there is a reference that it is in terms of Upendas.
Yes.
That having been interfered with.
Yes.
And there is a direction by the apex court.
Yes.
In respect of those writ petitioners before the apex court
Right.
seeking regularization.
Right.
We'll have to seek response from the respondents.
That's true, madam. But may I read that particular part of para 22, madam? Besides this, madam, we, in the light of decision of the Supreme Court of India in state of Punjab versus Jagjit Singh, reported in so and so, also direct the state government to pay minimum of the pay scale to masterful workers, work charged workers, and similarly placed employees working since last
The direction is in Upendas.
Yes, exactly.
Which got interfered with.
Yes.
So what is the position now? Yes, Mr. Bora.
Last occasion, Your Lordship, finance took time to get the status
They were supposed to bring the status.
Where is finance?
Finance.
The Council for Finance was permitted time to obtain instructions, however. No instructions are forthcoming, therefore further time granted to the Finance Department. Complete their instructions and apprise the court after 3 weeks. Mr. MP, Mr. Adhikari appears for the petitioner. List on 24th of July.
Okay.
Yeah, please, Lord. The matter pertains to two aspects. First is arrear salary, because the petitioner was deprived of drawing his arrear salary, and upgradation of his scale of pay, allowing him to draw a minimum amount of 41,815. On the previous occasion, respondents were supposed to bring their instructions.
Lordship, we have received instruction, Lordship. We may be allowed some time to file an affidavit, Lordship, and bring this on record.
You are Mr.
PR saying,
P.R. Sen appears for the petitioner. And the additional senior level advocate to the respondent, some instructions have been received. She prays for
2 weeks, Lordship.
2 weeks time to bring it on record by way of an affidavit. Prayer made is allowed. Release this matter after 3 weeks, enabling the petitioner to file any response if so advised to affidavit that is proposed to be filed by the state.
deeply.
Deeply obliged, Lordship.
Yeah, I'm challenging the selection process of the petitioner is the Anganwadi worker manager. As per the guidelines of the selection process.
My lord, I am
The-
appearing on behalf of person number 7, my lord. I need some time, my lord, to file affidavit in the
You are Mr.
caves.
The AOC
Caves.
appears for the caveat discharge.
This is already issued.
By order dated 28/11/2025, notices have been issued. However, steps were directed to be taken on respondent 7. However, today, caveat filed by the respondent 7 into the court. Mr. A. Hussain appears for the respondent number 7. He is permitted how much time you want?
My lord, 3 weeks.
3 weeks time to file his response. The state respondents are also permitted to complete their instructions and file necessary affidavit in the matter within 3 weeks. Release this matter again after 3 weeks on a date to be fixed by the registry.
Obliged.
Obliged.
Made to the Lordship.
Others, my lord, that is sent for finance approval, my lord.
Where is the finance?
It is appearing.
Finance? Who is there for finance? We'll take it up at 2 p.m. Yes, Mr. Solia.
Lordship, here we have received the proposal on 4th of June, Lordship. It is under process. Lordship, they are asking for first week of August. If the matter can be fixed by then, Lordship, they can bring it to the logical conclusion.
Yes.
By 4th of June, we had received the proposal.
Mr. A. Chalia, the Standing Council Finance,
Lordship.
submits that he has received instructions. That what have you received?
Lordship, the proposal was sent by the for SIU approval. Lordship, now after they process the file, the necessary approval can be given by August.
The proposal sent by the administrative department, namely the agriculture department, has been received by the finance department, and they have received the SIU approval.
Yes, for SIU approval, they have sent the proposal.
The finance department. So who has sent it for SIU?
Agriculture department.
The proposal sent by the administrative department, namely the agriculture department, for SIU approval has received. The Learned Standing Council Finance submits that matter is under consideration by the finance department. submits that the matter be listed in the first week of August, by which date he will have
update.
his complete
Yes.
instructions.
Yes.
10 months.
10th, all right. 10th of August. MS N. Soikia appears for the petitioner, MSG Bora for agriculture. Yes.
My lord, I was assailing a transfer order. And my lord, there was the instructions from, instructions sought for that, my choices, my lord.
The
So,
post that the posting is one of your choices.
my lord.
Yes.
So, do I have, my lord, that software? I have given 19 choices. My lord,
116 battalion is one of them.
my lord.
So
No, no, no.
No,
My
no,
lord,
no.
116 is not there, my lord.
That out of that, but out of means out of that choice postings. So this 116 battalion is not his choice posting.
okay.
That is clarified, my lord.
Then why is it given in your instructions placed before us?
Lordship, it was written some language is that out of that means now I have a talk with them and that out of that means the out of these postings, not out
So
of that 19. Not
19 is not
Not-
there. Besides 19, something else has been
yes.
Yes, my lord. So, my humble praise, my lords, have retained me for at least 6 months. I had instructions, instructions. And my lords, that other thing, my lord, that Ladit CCC was that they pointing out that there is a boarding school. My lord, that I cannot afford because the school fees is quarterly is 90,000. Hostel fees quarterly is 3,90,000. 3 lakhs, my lords. That I cannot afford. That point, my lord, I had sought personal appearance, personal audience with the DG, my lords. I will inform my lord, DG gave me indulgence and DG has rejected, my lords. And also, my lords, while representing before the authorities, my lord, I have given some choices, other choices. At page 25, ma'am. These are in the vicinity of Assam only, ma'am. 70, page 25, battalion 78. It's Kohima, battalion 173 is at Dimapur.
Your daughter is appearing for what?
Neat, my lord.
That is
Preparing
over.
for me. It's, my lord.
Which date?
Next year.
Next year. That can,
Well, the science, she's in the science student.
but
Well,
is it a ground in one of your
I have taken that.
no, in the circulars?
It's not there.
There,
It is
it's
not
not
there.
there.
It is not there.
Then
It's not. But I have a judgment. Proceedings in our division. My lord, reported in 2010 3 GLR 780.
yes.
And here also some, though it's related to us, government of Assam. My lord, these my lord, practice of transferring parents when the wards are children are at mid session has been, my lord, held deprecated. At paragraph 10 and 11, my lord. My lord, it's
Because these are things which the department should have their policies. Now, the fact that your daughter is appearing for a competitive exam,
my lord.
you will not be the only personnel. There will be hundreds across the country.
Once I understand, my lord, but I had recently served. I had served 3 years back. I was in Chhattisgarh. Man.
I can understand the exam is in a week, 10 days, 2 weeks, 3 weeks. I can understand that. But you are appearing next year.
My lord, I pray for at least 6 months, my lord, so I can accommodate things here, my lord, and go there, my lord. Or wherever
6 months is not possible.
My lord.
We can extend it by 1 month, 30
My
days.
My lord.
And then you settle your issues and then.
Well, the problem is that the petitioner's mother is also a cancer patient. Wife is
you
with
show
her.
us any policy whereby these are taken care of.
Well, I could have, my lord, stressed upon the first ground of cancer patient, but not that I'm not stressing because my wife is taking care of it. Otherwise, I was covered by that policy. Otherwise, I was covered, man. And this division means, my lord, says that it also, my lord, on that.
This is not in the middle of academics.
My lord.
It's not in the middle of academic.
It's middle of academic, my lord, because, my lord, see, the preparation takes some time, my lord. It's next year she will appear. My lord, she's in class 12 now. So it's mid-academic.
It's not academic in that sense of the matter. Academics means in your school or university exams, you are transferred out.
It's class 12.
Exams. It is like saying that someday somebody's child will be appearing for UPSC.
No,
and therefore
I'm not
the
on
person
that,
cannot
page
be
38, my
transferred
lord,
out.
kindly have a look. Page 38 of
38.
the identity card of the children.
38.
38.
This is what?
Class 12 science, my lord. Class 12, my lord. 11 and 12. It's science, my lord. Medical. Medicine.
What academy is this?
Well, this is a PNC Academy, my lord. It's a kind of
She's in class 12 now.
Class 12. And she's taking coaching also.
Yes, madam, what do you say?
Lordship, she is preparing for NEET. He is asking for 6 months, but again after 6 months he will come with the same prayer, Lordship. At least he needs just only yesterday the NEET exam was over for this year, Lordship. So 1 year retention after completion of the term, Lordship, it is difficult, Lordship. Then also, Lordship, his representation after his transfer was considered and it was rejected being devoid of merit. So far, his other prayer regarding mother's
that I'm not pressing.
that he himself is stated that his wife is the caregiver, Lordship. And regarding the school also, Lordship, there are his hostel facilities also, if necessary.
That I cannot afford, my lord. I have taken instructions. Quarterly fees is 90,000 and hostel fees another 3 lakhs. And that apart, my lords, the
quarterly fees he has to pay otherwise also. If she will stay in her home also, then also that study fees she has to pay.
But what is the meaning of this? Page number 43, clause 7. Special category retention. What is the meaning of this? What would be those special category treatment?
They have elucidated perhaps on these that subcategories of 1, 2, 3, 4, 5, 6. And my lord, that instruction that last occasion Madam placed before this court, it doesn't reflect anything because the lordship posted summary column. No reason recorded, my lord. It doesn't reflect also if my case was ever considered or not. Because there's a category other ground. Medical ground is there, couple cases there, LMC, MIB, infertility, OPS, terminal posting. Other grounds, what kind of other grounds?
And Morsha Lordship, he was already relieved because he had approached a very.
No, I was following the statutory prescriptions, man. I went to the DIG. When DIG refused, my lord, I went to the DG.
His representation was rejected on February 10th, and there on June 9th only he had filed this writ petition. And Morsha Lordship, regarding that, I have already stated in the last date, Lordship, that a board of officers were assembled and they considered all the representations. So out of 2461 representations, petitioners is one of them, Lordship. And out of
but your orders don't give any reasons.
Lordship,
Why?
today I have Lordship.
What are your reasons? Let us.
Yes, Lordship. Today I have brought those proceedings.
Lordship. From here, Lordship, we have recommended to reconsider his case out of his choice posting, but Lordship, I have marked it, Lordship. So that column number 10, that is by the this unit, Lordship. That we have recommended his recommended for reconsider his transfer and posted within preferences of choices submitted by individual. That recommendation has been also recommended by the sector, Lordship. Sector remark is the next column. But the board of officers who had assembled there, they had rejected, not recommended, Lordship.
But that not
And
recommended
not
also should be
recommended ground is also there, Lordship. One document is there that it is all the time not feasible to give choice posting. It has to be taken care of other aspect, whether anybody else is there who is more deserving or etc. Those things will have to be taken care of. That is also there. That signal is also there. Not from here we recommended before the BO, but they rejected this prayer.
I just had a glance man, of that document, whatever she has handed over. That also does not indicate anything.
See, the only ground you have is your daughter's study. Now the question is that you're a man of disciplined forces. You know that you have to be transferred.
That is
assuming it was a choice posting, then also you'll have to go.
Yes, Lord.
You look after your child.
But that arrangements can be made, madam.
What
this problem, my lords, that is the reason I'm seeking just limited prevalence 6 months.
No, what arrangements you want to make?
Well, some alternative has to be made.
So you make it. Why do you want 6 months?
I need 6 months for that, madam. And even then, my lord, it's a submission of the respondent also that the unit had recommended my retention.
They have, but the board has
not
rejected.
retention, only to transfer at his reconsider on the choice posting.
But the board has rejected.
Board rejects, my lord, without any reason, nothing, my lord. There are batch of cases coming like this. Simplicity not recommended.
What reasons are expected? Reasons will have to be
Yes,
understood.
Lord. His representations were submitted, so they
in
consider
terms of the transfer policy.
Well, anybody
your ground for consideration does not find any place in view of the policy. Policy
that I understand. That is why I'm before this court, my lord. Because policy might not be there, but being true to the situation, my lord, sometimes it needs my lord, some extraordinary, my lord.
No, the extraordinary, yes, but extraordinary should not be to the extent that it will be used as a precedent.
That I understand. It should not be. It's a precedent.
Therefore, you give a undertaking that 30 days, all right, we can extend it by 30 days. You make alternative arrangements and go. That much we can do. Certainly.
Then, my lord, I'll have to take the instructions.
You take your instructions.
Well,
we'll come back day after.
Well,
release this matter day after tomorrow, enabling the council of the petitioner to his required instructions.
Well, status quo was given till 3 months.
Status quo we extended till 24.
20. Public.
Ready. Mr. Das, what are your rules and regulations, OMs, in respect of transfer and posting regarding persons with benchmark disability in terms of the Disability Act?
I have to take the instructions, right? There. Just before sometime only I received the copy.
Subject copy.
Heard Mr. J.M. Chaudhary, Learned Accountant, Mr. R.M. Das. Is that department a party? No.
No.
Mr. R.M. Das is requested representing the Department of
Social Justice and Empowerment.
Social Justice and Empowerment, Government of Assam, to apprise the court as to the existence of any policy notification of when with regard to transfer and posting person with benchmark disability. So, counsel for the petitioner has referred to and relied upon the OM issued by the Government of India. Where is that?
It's page,
Dated
my lord, 20. Then page 30.
relied on the OM issued by the Government of India. So, the respondent authority, however, while issuing the impugned order dated 17/6/2026, submits that these guidelines are guidelines issued by the Government of India so far as state of Assam is concerned. Such guidelines are there. Under such circumstances, the court has requested Mr. Arvind Das to apprise the court on these aspects. Mr. G. Godoloy appears for the respondent authorities. Release this matter immediately after reopening, 15th of July, on which date the Mr. Das will obtain required instructions. The matter. So, considering the rights, considering the Central Statute of Rights of Persons with Disability Act of 16, the protection granted to persons with benchmark disability, and the presence of the OM, and the existence of the OM dated 2024 issued by the Department of Personnel, Government of Assam, Government of India. If the next date fixed, the impugned order dated so and so shall remain state. Released on 15th.
Public. My name may be.
Mr. Raran, the names of Mr. Raran Das be reflected. Petitioner will ensure service of copies of the writ petitioner along with all enclosures within 2 days. 2 working days. Copy of this order be marked to Mr. Raran Das for enabling him to obtain required instructions.
Notice no, sir, madam, well, I have gone through the order. There is no as such positive direction. And the other part, my lord.
Whatever it may be, when the notices are there, the
I am
forest
appearing now,
department
madam.
is
I am
supposed to
appearing.
appear.
And the other part, madam, with the same prayers.
Obtain your instructions and we'll take it up after reopening.
No, madam, what I'm trying to convey is, madam, with the same prayers, madam, that you have not opened the seal cover, whatever, madam, the petitioner has filed another repetition. Same prayers.
Prayer cannot be same in content and repetition.
No, no. He's asking for consequential benefits.
You get your instructions insofar as this compliance of the order is.
Madam, kindly see the order date, madam. Kindly the order, madam. The order which they say I have been not compliant, madam.
Yes.
Madam, there is no positive direction. Court has itself done everything.
What was the impugned order?
My lord, he was assailing a
order of penalty, madam.
Penalty was imposed.
You're referring to the order at page number 13.
I don't know.
Page 12, madam, the relevant.
Order
Page
dated
18, madam.
Order dated
Page
25
18.
to 25 to 25.
Last page of 14 and 15.
What is the direction?
Direction, madam, there was no direction. Court itself passed the penalty.
Penalty order was passed, madam, and now they have to pass the consequential order, madam. That has not been passed, madam.
There is no indication of this such.
That is not required, madam.
Now he has approached
once the penalty order was passed, my lord, they should have passed the consequential order, madam.
That not having been passed, how do you So where is the violation of the order?
Because my lord, they have not passed the consequential order.
But will a contempt lie there?
Let them
Contempt
respond.
is for willful deliberate violation.
Yes, my lord. Because
The court has set aside the order.
yes, my lord. Subsequently,
Court did not,
subsequently,
court
nothing.
did not pass any order saying that consequential orders of reinstatement, etc., should be passed.
Question of reinstatement doesn't matter because that was a minor penalty, my lord. But now, my lord, because of since they have not withdrawn the impugn order from their end, my lord, that is why, my lord, they are
It's
not
the
giving.
question of withdrawal. The order has been set aside.
Yes, my lord.
Here's the question of withdrawal.
After that, my lord, no consequential order passed by the department, my lord. That is why, my lord, my subsequent promotion that has been held up, my lord.
And for that, he has approached this honorable court by filing another repetition of this in this
Yes,
year,
ma'am.
my lords.
We have filed for my promotion, my lord. But since no order has been passed, subsequent this
And
order
that,
of this court, my lord.
and that matter, my lord, is fixed for motion again after 4 weeks. He's asking for every consequential things out there, my lords.
What is that impugned order 1/124?
But it was a penalty, my lord.
Penalty order.
Yes, my lord. Minor penalty was imposed upon him.
So that is set aside.
That is citizen.
Then what for you want the contempt?
Subsequent year to, my lord, no consequential order passed by the
What is that consequential order? What consequential orders you want?
to giving it, withdrawing the penalty order, my lord, from their side, my lord.
That order is set aside.
Yes, that I understand, my lord.
Where is the scope to withdraw it?
That is because, my lord,
The order is non-existent.
yes. But, my lord, on the guise of that, my lord, now they are denying the promotion, my lord.
It's a different ground.
That is why, my lord, separate petition has been
But
filed.
where is the contempt? Once the order is set aside, there's no requirement of issuing another official order to say that this order is set aside. It is not in existence.
Normally they do, my lord. Normally they do.
Normally they do is a different issue, but it doesn't.
Normally they
require
do.
anything.
And on the guise of that, my lord, now they are denying my promotion, my lord. So let them respond, my lord.
Do you have the impugned order 1/124 here? The contempt petition.
No, my lord. Today, no. The contempt petition is not an my lord.
You have already pursued it. There's no point keeping this petition pending. What for?
Well, let them respond, my lord. Why they,
What
He will
is
get
there to
all his
respond?
reliefs in another repetition, my lords. He has already
You are
filed.
filing a contempt for willful deliberate violation of the court's order.
yes, my lord.
What is the court's direction?
Court has
Firstly, there is no direction.
set aside the
Court has concluded that the impugned order is bad, therefore set aside.
yes, my lord.
There is no consequential action required on behalf of the respondents to issue another order, withdrawing that order, because
Normally,
the
my
order
lord,
is non-existent.
normally, my lord, department do, my lord. And now, my lord, on the guise of that, my lord, now they are denying me promotion, my lord.
That will be examined in the writ petition you have filed. That will be examined in the writ petition that is filed.
So in that case, my lord, this contempt may be tagged with the repetition, my lord.
Let this contempt petition be listed along with WPC number
2219 of 26.
2219 of 2026. As it is submitted that the writ petitioner has filed another writ petition challenging the inaction on the part of the respondents in proceeding to consider the case of the petitioner for promotion to the next higher post. Ordered accordingly. Yes.
Ordered.
Mr. D. Gogoi appears for the respondents. So,
Bad result. In this case, I need another 3 weeks time. Oh.
Your suspension matter was based on the suspension way back. It was
1911-9.
yes, my lord. It was
So on 11/9/2025.
Departmental proceedings.
No,
not
nothing has been
initiated.
done, man.
Lord,
Now,
I
recently,
don't have any instruction.
then recently they have issued a extension order that is on 11/5/2026, man. With a retrospective effect. But that kind of.
Retrospective.
Yes.
You bring it on record.
I can do it, but I'll let your lordship follow.
You can bring it on record.
After vacation, Lordship, by this time.
Honestly,
You are receiving your subsistence allowance.
I'm getting a message. That's not, but that honestly they have been depriving me, man. Under 90 days, they ought to have been issued their extension order, but now
Proceedings are not initiated.
nothing is happening. No so notice, nothing. They say that Westwest was suspended by notification dated 11/9. Considering the serious no charges, period of suspension to extended to 90 days. So 3 months. That is on 16/1.
Suspension is under which provision?
Another Assam discipline appeal rules, my lord.
I don't know. Which provision?
Because of your lordship find that they have faced it. There was an FIR, my lord. On the basis of the FIR, pending initiation of department proceeding, they have under Rule 6(1).
Where is the order of suspension?
On 11/9.
Page number?
Page 22, man. 90 days expired on the month of December, 11th of December.
Mr. P. Kotoki, Senior Counsel, assisted by MS and MSDD Bormon, Learned Counsel, representing State Council, representing
All right.
all the respondents. Petitioner before this court, assailing the impugned order dated 19/9/2025, whereby the petitioner was placed under suspension under Rule 6, within bracket 1, the Assam Services brackets Discipline and Appeal brackets Rules 1964. Stop. Petitioner was at the relevant point in time serving as additional superintendent of police in bracket crime. Is submitted by Mr. Kotoki that the notwithstanding the petitioner being suspended with effect from 11/9/2025, no review was initially carried out extending the suspension. That department disciplinary proceedings, to the best of the knowledge of the writ petitioner, has been issued, has been carried out by the respondent department. Show cause notice, a memorandum of charges have been issued. So, under such circumstances, the petitioner is before this court submitting that the prolonged suspension of the writ petitioner without initiating any inquiry and non-review of the same is violative of the settled principles of law and also the provisions of the Act, of the rules. Therefore, the same is for interference. So, Mr. Kotoki has placed before the court a notification dated 11/5/2026, whereby the review authority, whether the review committee was constituted to review the case of suspension, giving it retrospective effect.
Last line, man. Therefore, the governor of Assam is pleased to extend the period of suspension in respect of for a period of 3 months with effect from 11/12/2012 on forever. So 11 is
And
expired,
this
so
suspension was extended for a further period of 3 months with effect from 11/12/2025 or until further orders. So, he submits that since the period of 11/12/2025 expired long back, the petitioner should be reinstated in service with all service benefits. Where MS Bormon, on the other hand, submits that she has no instructions in the matter.
As per request of the Assistant Inspector General of Police, the further time.
They submitted on instructions that further time is sought for the department to complete for the necessary instructions. We have it immediately after vacation. Yes. Considering the submissions made, the matter is directed to be listed on 16th of July.
Okay.
Endeavor will be made to dispose of that now. Endeavor will be made to dispose of the matter on the next date of listing. We'll bring it on record. We'll bring it on record.
Fine.
Petitioner is permitted to file additional affidavits to bring on record additional pleadings if so advised. Yes,
Lordship, we have received the paradise from us, we would like to file affidavit.
yes, Mr. Bodago.
Lordship, they can. Only thing, your lordship, there, my case essentially is that your lordship, the suspension was made, your lordship, on 5/12/2025, your lordship. Search sheet was issued on 27/3/2026, much after your lordship, the 3 months period that is required to be fully.
What is the stage of inquiry?
No, they notice.
Yes, show cause notice has been issued.
And interestingly, your lordship, the allegation were against around 7 officers, your lordship.
Where is the order of suspension?
Lordship, that your lordship, page 33. He was arrested, your lordship. On the very next day, bail was granted under Rule 6(2).
Mr. S. Botakur, Learner Senior Counsel, assisted by Mr.
P. Khatonian.
P.
Khatonian.
Karonian, and Mr. D. Bora, Learned State Counsel, representing the respondents. Mr. Bora submits that the instructions have been received.
Yes, sir.
Like to bring it on record by way of an affidavit, if raised for 3 weeks' time. Mr. Botakur, on the other hand, submits that the suspension order was issued on 5th of December 2025, and no review was carried out.
Lordship.
And no proceedings have recently been, the charge sheet has been, memo of charges have been recently issued. However, as mandated under law, the review was not carried out within 3 months. Therefore, it is submitted that the impugned order be set aside and quashed. Let the respondents file their response immediately after 2 weeks, matter be listed thereafter.
Before a date is over. After vacation. As per your lordship.
24th of
Lordship.
July, it is on 24th.
47 also your lordship, same issue, same department, your lordship.
All right, 47 also same
Lordship.
orders,
DPO.
same date. 47, Mr. C.K.S. Mumbai, appears from the state.
And received a paradise for that. So earlier order dated matter was fit for complete instruction and earlier necessary.
They did not serve the extra copy till date. You could not obtain the.
Counsel for the respondents submit that they could not complete their instructions as extra copies as directed by the court was not submitted. Counsel for the petitioner undertakes to serve copies within 3 working days. Matter be listed thereafter for 3 weeks. No date. First serve copies. After reopening, you make a mention if it is not listed. Right? Mr. J. Handik for revenue 1 and 2. Mr. P. Sogia for 3. Yes.
Matter lordship was also issued multiple interim memo. This petitioner, your lordship, was initially discharged from service in 97.
Who's for the respondent?
That initial discharge order was set aside earlier in 2013, Your Lordship. Then again, second show cause notice was issued and he was again discharged, Your Lordship. That was also put to challenge and that has been set aside with the direction that the petitioner should be reinstated in service and he should be considered to be continuing his service. And further granting them liberty that if they want to continue, Your Lordship, within 1 month they have to serve a show cause notice to him. But till date he has not been reinstated. But after about 3 months, a show cause notice has been issued, Your Lordship, in violation of the court's order.
Mr. Dor, any instructions here?
No, my lord, not yet. We are still awaiting instruction, my lord.
Mr. M.H. Loskor for the petitioner, Mr. R. Dor for the respondent, Mr. Dor submits that instructions are awaited in praise for 3 weeks' time. Matter be listed again on 31st of July, permitting the respondents to complete their instructions and file necessary affidavit if so advised. Interim order passed earlier will continue till the next date of this.
Meantime, they may be directed to issue him reinstatement order because that is the specific order of the court. But you would kindly see page 60 for a moment.
Is there any contempt file?
Contempt also filed.
So you urge that prayer before the contempt court.
I think they are, but Your Lordship, they are also, Your Lordship can.
You are challenging, you are not filing the writ petition for insistence on that order.
And that is also one of the prayers to reinstate him.
Huh?
That is also one of the prayers to reinstate.
How can that be?
Because already this court has.
This court has done, it has not been carried out. You filed a contempt. Then, once an order is there, why do you ask for another order?
Page 60, Your Lordship.
We have already given you protection, no coercive action.
Yes, yes.
Then let them file it.
Instruction was issued regarding.
Lordship, in this case, Lordship, now Lordship, the Social Justice and Empowerment Department is there look after the disability of this person.
They are to look after.
That it is a matter relating to disability of the person with disability. Lordship. So now it is Lordship, the file is transferred to the Social Justice and Empowerment. So I am the standing counsel.
So they are already a party here. Respondent number 2.
And they are Lordship Social Welfare Department.
No, respondent 2.
Director of Social Welfare has no role now. Director of Social Welfare Department, Lordship, respondent number 1 and 5, Lordship. They have no role, Lordship. Now the Department of Social Justice and Empowerment.
You are a government council, you obtain instructions from this department. You can't keep on inviting the standing council. It is not there, you are there, you obtain instructions. Tell us. Mr. A.Y. Chaudhary for the petitioner, Ms. D.D. Burman, Learned State Council, submits that the matter is presently the administrative department in respect of monitoring and supervising the claims of persons with disability is presently the Commissioner and Secretary Government of Assam Social Justice and Empowerment Department. Stop. It was earlier with the Department of Social Welfare, and after creation of the new Department of Social Justice and Empowerment, the matter is presently being dealt with by the same department. Stop. It is submitted that there is a standing council. The standing council, however, is not present in court. We permit MSDD Burman to obtain required instructions in the matter. Released again on
After vacation.
after vacation on the date to be fixed by the registry.
Public.
I am sorry, interim order may be continued.
We have already done it.
Big lordship. Mr. H. Gupta, he is in another lake, so my lord. I think better he will come after vacation.
That's hardly a ground. You are there in the CGC. If he's not there, you should. What is the
Affidavit not filed in this case.
affidavit not filed?
Then file affidavit.
Yes, sir.
Matter is listed after the returnable date. The MSA guy appears for the CGC appears for the respondents. They are permitted to complete their instructions and file necessary affidavit if so advised. Mr. Richard Anand for the petitioner released the matter again after 3 weeks. Yes.
Kindly there is the last one.
Yes.
Well, Lordship, the conversion is almost complete, Lordship. I was informed by the officers, Lordship, that today they are making the challan. So I think within this week, Lordship, the petitioner will get her first pension as an old pensioner under the old pension scheme. So, Lordship, a similar matter has been fixed on 15th of July. Say, so, Lordship, I'll pray for a similar date, Lordship. By then, the payment.
Yes.
I have the one instruction of dated of 16/6 where the conversion has been completed, but Lordship, some check needs to be deposited. Only then they can create the challan. So these are some formalities, Lordship. Yes.
So also appears for the writ petitioner, Mr. A. Chalia appears for the Finance Department. Mr. Chalia is placed before the court an office order dated 19/6/2026, whereby it is seen that sanction is accorded for drawal of an amount not exceeding is 13,47,479.77. This amount represents the erroneous deposit of the state government employee and the government matching contributions inclusive of interest received from NSDL and deposited in the state nodal officer's NPS account. Stop the withdrawal is authorized as a refund withdrawal. In favor of the writ petition. Where Mr. Cholia submits that steps are being taken to ensure that the petitioner receives his pension under the old pension rules, and certain formalities are required to be completed regarding the withdrawal and deposit of the money.
Yes.
The contributions which made by the petitioner as also the state, as was earlier done on the
New pension,
NPS.
yes.
So submits that the matter be relisted after the ensuing vacation, at which time the
WPC I have with 370
steps are likely to be completed. Mr. Cholia submits that a similar matter is listed on 15th of July, being WPC number
37 of 2025.
370
37.
of
2025.
2025. He submits that this matter be also listed on the same day. Where counsel for the petitioner does not object to the prayer made. Accordingly, release this matter again 15th of July along with WPC so and so. Mr. Radhor, Sericulture Department, MS Ibora for BTC, MS H. Sharma for Accountant General.
Can may be granted to file affidavit. Affidavit not done.
MSS Bora for the petitioner, MSA Guy and Learner CDC reviews our prayer for filing affidavit. She prays for 4 weeks' time. Prayer made is not objected to. Accordingly, release this matter again after 4 weeks.
Give a date, my lord.
You mentioned after 4 weeks, if it is not 5.
They are taking a last order, kindly see last order. Today they are to file.
You make a mention after what today is 22nd.
It's for last order, today they are.
All right, released on 27th of July.
Ask my
Yes.
Earlier, Attendant Lordship was pleased to ask to based on information from the respondent authority whether the SASIT was issued and served within the mandatory period or not, whether subsistence allowance paid and is paid or not. Both are not done, madam.
Subsistence allowance not paid.
Not paid. Still paid.
Lordship sanction.
8 months over, 8 months long.
Well,
It will be disposed of, madam.
Lordship, the subsistence allowance is sanction order is issued.
when was the petitioner suspended?
11/11/25.
25, you're not giving him suspension, the subsistence allowance.
8 months over.
How will the petitioner survive?
Lordship, it is released. Sanction is granted, Your Lordship, on 9/6/2026.
Petitioner haven't received anything.
You pay interest for delayed payment, delayed sanction. Secondly, what happens to the proceedings? Any proceedings initiated?
Your Lordship, yes, sir. Your Lordship in the green flag. On 16/6, so far statement of
Only on this month after receiving the lordship order, madam. After receiving the lordship instruction,
Where is the suspension order?
page 18, lordship. May I read out?
Yes.
Here is the intimation letter block development officers, Indira Development Block, Ujai, by so and so number dated 17/11/25 and the later intimation video from the Inspector of Police Investigation Officer, Director of Vigilance and Anti-Corruption, Assam, Simantapur, Gauhati, by so and so that Chaudhuri, Assistant Engineer, Vegan Development Block Officer, was arrested on 11/11/25 in connection with a case of demanding and accepting the money of ₹7,000 from the complainant of this case. Also produced the detailed report received from the Senior Superintendent of Police, Director of Vigilance Anti-Corruption, so and so.
You have the judgment of the division bench.
My lord, Supreme Court judgment and the division bench, my lord, and the single bench. Law is settled, my lord. So for departmental proceedings and other, my lord, that is, my lord, petitioner fate will be decided subject to the decision of departmental proceedings. So far, my lord, that lordship is able, just I am refreshing your lordship memory, my lord. Basing on the Ajay Kumar Chaudhuri, my lord, that is lordship is able, my lord.
There's a division bench.
Yes,
judgment
ma'am.
of this
Yes,
case.
yes, ma'am. Paragraph 10 is given. Sorry, my lord, that is my cookie. They said, my lord, have some good marks and all. And numbers of single bench order, my lord. Passing the suspension order and reinstate the petitions.
Charge sheet has been issued.
No, man.
Yes.
Huh?
Charge has been issued
When?
on 16/6.
This after receiving the court order, madam. That 8 months, nothing, madam. Mandatory period is 90 days, 3 months. It has been settled by the Honorable Apex Court and our division bench and members of.
Now, you are serving as what?
Eastern Engineering.
Okay. There is a division bench judgment of this court. You are
Yes.
aware?
Yes.
As per the division bench, the principal in Ajay Chaudhary is applicable suspension under 6(2).
Yes, it's a deemed suspension.
Deemed suspension. You have not continued with the, you have not issued.
And there are single bench judgment also, madam. Questioning the suspension order.
If the since this charge is now served upon him, if the scenario is same, as per the order should be itself.
That was not having within the mandatory period after 8 months.
The order should be
This is single bench.
after 7 years.
In this writ appeal judgment, what were the facts? Was there a charge sheet served? There was no charge sheet served
No, sir.
in the writ appeal that you are relying on.
Well, only one copy, madam. I am sorry.
Now you can take this copy. There are 2 copies here.
No, both, sir. There is a coding with bench judgment also. That is given.
The writ appeal judgment.
That is a single bench judgment, madam. It is a single bench. Relying in basing the Supreme Court judgment and the division bench judgment for this order.
No, in the facts of that case, there is, I don't find any reference of whether charge sheet was served on the appellant or not in this case.
Sir, but in my case, madam, so far the mandatory period settled by the Honorable Supreme Court, madam. That was in the last 8 months not served, madam. Now the Nalan Barry submitted that now served, madam. Okay. Within 90 days, nothing served, madam. Until date, no substitution error.
A show cause notice was served.
Yes,
Para number 7 in the writ appeal judgment.
What's it the order should be also in the paragraph.
No, you read the judgment, division bench judgment. Binding on us, you don't have a copy.
If they in the division bench matter, they are also charged were served, but then no review order was passed. Here, no review order was passed.
That's right. Same is the case here.
Here also we have reviewed it,
You have reviewed it only now. When did you review it?
This month.
Not within 90 days.
No, this month, after 8 months.
6.
6, madam.
Number one, this is, besides being violative of the division bench, it is violative of your own circular issued by the Chief Secretary. Then it must be served within 90 days, reviewed within 90 days.
Number of coordinators.
You are posted as executive engineer where?
No, executive engineer. No.
Assistant executive. Bina Kandi. So we'll allow the writ petition interfering with the suspension order, but we'll give liberty to the state to post him in any other place
Okay.
during the pendency of the.
It is up to your discussion.
But Mr. M. Ahmed, Learned Counsel, Mr. K. Kumar, additional AG, appearing with the state. The petitioner before this court is serving as assistant engineer in the Panchayat and Rural Development Department, Binakandi Development Block, Doboka, Hojai. So, during his service, petitioner was arrested on 11/11/25 in connection with ACB case number ACB PS 58 of 2025 under section 7, capital A, small a of the PC Act of 1988 on charges of demanding and accepting illegal gratification from the complainant. So, petitioner was therefore arrested, although subsequently released on bail. So, since the petitioner was detained in custody for more than 48 hours, the petitioner was suspended under Rule 6.1 and 6.2 of the Assam Services Discipline and Appeals 1964. Subsequent to the petitioner being granted bail on 12/12/25, the petitioner approached the authority seeking reinstatement in service and release of subsistence allowance. So, the representation was filed on 2/1/2026. Thereafter, he filed another 2 representations, being representation dated 6/3/26 and 27/3/2026, requesting for reinstatement in service and payment of subsistence allowance. So, however, the respondents did not pass any orders on these prayers made in the representation. Being agreed, the writ petitioner has approached his court by filing the present writ petition. The senior counsel appearing for the petitioner submits that the petitioner's prolonged suspension, violative of the law laid down by the apex court in Alia Chaudhary reported in so and so, as also Rakabuddin Ahmed, which is the judgment of the division bench of this court reported in so and so. So, it is submitted that the petitioner having been suspended with effect from so and so date, no proceedings were initiated, nor was his suspension reviewed as required under the rules. So, therefore, the petitioner's prolonged suspension is illegal and contrary to the rules and should therefore be interfered with, set aside, and the petitioner be reinstated in service with full back wages and service benefits, including the subsistence allowance, which was due to the petitioner during his period of under suspension, and which the respondents failed to release. In spite of notices being issued 6/5/2026, the respondents have not filed their affidavit. Mr. Kumar appears before the court and submits that he has instructions to submit that the show cause notice, the memorandum of charges have been issued by the department on which date? On 16/6/2026. The petitioner has been called upon to respond. He further submits that the suspension was also reviewed by the order dated 8/6/2026.
6/6 and 8/6.
6/6 and 8/6. Whereby the respondents reviewed the suspension and for another period of 3 months. With effect from 11/5/2026 to 10/8/2026. So,
Your Lordship, as per 6/6 review order, Your Lordship, it is which effect from 11/2/26 to 10/5/2026.
Suspension by 2 orders. By order dated 6/6/2026, suspension was reviewed and extended for a period from 11/2/26 to 10/5/2026, and subsequently by order dated 8/6/2026, it was extended from 10/5/26 to 10/8/2026. So it is submitted that the judgment of the apex court in Ajay Chaudhary ultimately did not interfere with the order of suspension in view of the show cause notice being issued to the appellant / petitioner before the Supreme Court. The court submits that since the show cause notices have been issued, direction to revoke suspension prayer for revoking the suspension may be rejected. So, what is your submission regarding the division bench judgment?
Your Lordship, since the apex court itself not interfere in the suspension order.
It is submitted that since the judgment of the apex court rendered in Ajay Chaudhary, reported in so and so, did not interfere with the suspension order of the appellant and petitioner therein, the findings of the division bench did not take note of findings by the apex court. Therefore, the finding rendered by the apex court will be. Counsel for the parties have been heard, pleading the relevant record have been carefully produced. The petition was suspended on so and so. Thereafter, till when was he suspended?
11/11/25. 512.
512.
Hmm?
512.
512.
512.
512.
Now 90 days will be from which date?
On the date of communication, Your Lordship, that he has been released on bail.
When did he communicate?
Past implementation, that is 2/1/26.
What is the judgment where this coordinate bench had ordered that 90 days will be from the date of communication?
Your Lordship, in the Rafael Ali case.
Rafael. Where is your first representation?
That is page 24. Looks. There are three events. First one is 2/1.
Illegally. Was arrested on 11/11/2025. So, as per the judgment of Rafael Ali, reported in so and so, give the citation. Coordinate bench of the court of this court had ordered that the period of 90 days in respect of persons were suspended in pursuance to Rule 6(2) of the rules under 1964, the period of 90 days in such cases of deemed suspension will be counted from the day when the petitioner informs the court, informs the authority upon being released on bail or released from custody. So, the petitioner was released on bail on 12/12/2025.
15/12/2025.
15/12/2025. And he intimated the authorities on 2/1/2026. So, therefore, period of 90 days from 2/1/2026. Stop. A division bench of this court in Rakibuddin reported in so and so by referring to the judgment of the Ajay Kumar Chaudhary, reported Apex Court judgment. Ajay Kumar Chaudhary reported in so and so that in a similar matter, the reference made in view of conflicting judgments
rendered by coordinate benches rendered in Diswajit Day versus State of Assam, WPC 2401 of 2019, and Atfur Rahman versus State of Assam, in bracket WPC 6842 of 2018. Kumar, examine the matter from the perspective of the law laid down by the apex court in Ajay Kumar Chaudhary, read with the rules of 1964. Stop. The facts pertaining to Hakimuddin, in bracket Supra. At para 7, it is seen that the show cause notice containing the charges against the writ petition appellant was issued on 16/6/2019. Writ petition appellant therein 16/6/2019. Stop. However, order was passed reviewing the requirement of continuing under suspension, and the said position exists till date. Stop. Suspension of the bundle of the matter was thereafter examined extensively, and reference to the judgment of Ajay Chaudhary was referred to. Ultimately, the court held that the principle laid down in Ajay Chaudhary would also be applicable in a case of deemed suspension under section 6(2) of the rules of 1964. The division bench answered the reference by holding that the periodic review in the case of deemed suspension is mandatory, and the requirement of deemed suspension is mandatory. So, coming to the facts of this case, it is seen that the spiral binding ethical suspension, no, coming to the facts of this case, it is seen that in the present writ petition, the petitioner was suspended with effect from so and so date, and no review as mandated under the rules was carried out within a period of 3 months from the date of suspension. So, although the petition respondents have submitted instructions that charge sheets, memo of charges have been issued on 16/6, and the petitioner has been called upon to submit a reply, and the suspension was also reviewed on 16/6 and
6/6 and 8/6.
8/6. Fact remains that the review of suspension within the 90 days is held to be mandatory by the division bench of this court. Has not been carried out. Stop. In this context, it is also relevant to refer to judgment, another division bench judgment of this court rendered in Ajit Sunwal, reported in 2023 6 GLT 115, wherein this court, by referring to various Supreme Court judgments, including the judgment of Rakibuddin Supra. The division bench categorically held that unless the review is held within 90 days in order of suspension, including the one issued to for a detention of an employee in custody for more than 48 hours, would not survive, and nor can such order be granted fresh lease of life by carrying out a review after the expiry of 90 days. So, the relevant provisions, the relevant paragraphs in the judgment of Rakibuddin, as also the judgment of Ajit Sunwal, are extracted below. Case of Rakibuddin, para 15 onwards, and Ajit Sunwal, para 13. Considering the above position in law rendered by the apex court and also by this court, and the facts and circumstances in the present proceedings, this court is of the view that the impugned suspension order dated so and so cannot withstand the scrutiny of law in view of the fact that the continuance of the suspension order by way of review was not carried out as is mandatorily required within a period of 90 days. Stop. The impugned suspension order therefore stands set aside. Petitioner is directed to be reinstated in service with full benefits, service benefits. Stop. The release of any subsistence allowance that may have been pending during the pendency, during the suspension period, is also directed to be released. So, the department may proceed. Department will proceed in terms of the show cause notice issued as per the provisions of Discipline and Appeal Rules under 1964, pursuant to the issuance of the show cause notice. So, considering the fact that the petitioner was detained in connection with a case where allegation of illegal gratification was leveled, and an FIR, an investigation in this connection is carried out in connection with the CV case number so and so. the authorities are at liberty reinstate the petitioner and post him at any non-sensitive place, non-sensitive post as deemed fit and proper. Petition accordingly allowed, disposed of. Yes,
My lord, may I take up 57.
57.
My lord, in fact, the other day, I have submitted before your lordship, my lord, that the case of the petitioner for promotion to the post of professor, my lord, is being, my lord, now denied in view of the fact, my lord, that there is a, my lord, order in respect of promotion to the reader is, my lord, passed belatedly. And in this connection, my lord, I relied on a similar order passed by your lordships in a connected case, my lord. Now, the query put by your lordships was, in that case, my lord, there is already an order passed by this court. Whether, my lord, such an order exists in my case, my lord. My lord, I have also a similar order. In that case, my lord, this honorable court directed to consider, my lord, the case of the petitioner as a lecturer, my lord, from the date when she has acquired, my lord, the post of MDS. In my case also, there is an order.
You did not point out that.
Yes, I am sorry, my lord, because that observation, my lord,
passed this order.
yes, my lord. That observation is already there. My lord, this is my mistake, my lord. That order, your lordship will find that order, page 66, my lord, annexure 17. If your lordship comes to page 68, my lord, para 4, the grievance of the petitioner is that the petitioner has not been designated as lecturer in terms of notification dated so and so, issued by the Health and Family Welfare Department from so and so, the date on which he obtained MDS degree, and to enable him to participate in the selection process for promotion to the post of reader. Now, next page, my lord, para 6. Here, the honorable court directed to redesignate my post, my lord, of tutor as lecturer with effect from the date when I have, my lord, acquired the degree of MDS. Para 6, my lord, last 3 lines. In that view of the matter, respondents are directed to redesignate the post of tutor held by the petitioner as lecturer with effect from so and so. Now, my lord, my humble submission is the requirement, my lord, for the post of professor is MDS degree and, my lord, 4 years as lecturer, and subsequently, my lord, 5 years as reader. Now, considering, my lord, if the experience, my lord, teaching experience is, my lord, counted from 2017, I have 4 years experience of lecturer, my lord. Up to 21, I have 4 years of lecture experience, my lord. From 21 to 20, my lord, 15, my lord, June, I would be, my lord, eligible for the post of, my lord, reader, 5 years experience. I would have the experience of 5 years as reader. And in that view of the matter, my lord, I am eligible. I meet the eligibility criteria for the post of professor, my lord. Now, while issuing notice, my lord, in the identical case, if your lordship takes up, my lord,
We had passed some order. If this order was there, you should have pointed out. We have already passed an order on 17/6.
Yes, no, your lordship say that your lordship will consider interim order today. Last part.
What is that interim that you want?
I want, my lord, that my documents be forwarded to the DPC for consideration, as your lordship had passed, my lord, the order in the other case.
Yes, Mr. Gugoi.
Well, in the
Are they identical?
my lord, I have got the instruction parawise common in the first case, which lordship is taking up now. As per my instruction, my lord, in fact, in the new case, the petitioner has now annexed the, my lord, regulation which will be applicable for promotion to the post of principal. Professor.
What are you challenging to in the subsequent writ petition?
My lord, the belated, my lord,
Fresh writ petition.
Fresh writ petition, my lord, in the earlier case, I did not challenge it, my lord. I ought to have, my lord, not giving the retrospective effect of promotion in the post of reader, because I become eligible in 21, like the other case, my lord. In the other case also, the petitioner has challenged, my lord, the same, my lord, order, my lord, promoting belatedly, not giving retrospective effect. If the, my lord, a promotion order was passed at time, I acquired a, my lord, qualification of 5 years of teaching experience. That was not considered.
Yes.
My lord, will kindly have a look at page 88 of the, my lord, new writ petition. That regulation has been annexed. The proper one.
88.
Yes, 85, my lord, it starts.
Lordship will see it is the, my lord, Dental Council of India Master of Dental Surgery Course Regulation 2017. In the regional learning college, this is the regulation that will be applicable.
88.
85, my lord, the regulation starts.
All right.
So relevant part will be 88. Lordship will see at the tops, it is a regulation number 17. Age, educational qualification and teaching experience. Lordship will see the C, reader, associate professor and reader. A bachelor degree in dental surgery from an Indian university with masters in dental surgery and diplomate of national board recognized by the government of India on the recommendation of the council and with 4 years of teaching experience in the specialty after post-graduation and shall have to acquire minimum points for publication as per scheme given in the table. The Lordship will see down below there is a table. For the, in page 89, just before this heading important, before the total score required for head of the department 40 marks, professor 30 marks, for reader 20 marks. My lord, petitioner required this particular marks, my lord, in April 2021. The DPC was held in 2020. So by any means,
he acquired these marks as required for a reader.
For a reader. In April 2021. And the DPC was held in 2020, thereafter in 2023. Now in 2023, his case was considered. And in 2024, after that, my lord, DPC, he was given the promotion to the post of reader. Well, there is no such law as on date, my lord, that moment a person becomes eligible, he will have to be immediately, DPC will be held for that particular person and he will have to be promoted. So, my lord, even if we hold that, my lord,
Now he is asking for a promotion to the post of professor.
Now, Lordship will see what is the criteria for professor. B, a bachelor's degree in dental surgery, page 88 again. A bachelor's degree in dental surgery from an Indian university with masters in dental surgery, diplomate of national board recognized by the government of India on the recommendation of the council and with 5 years of teaching experience in specialty as reader, associate professor, and shall have to acquire minimum points of publication as per the scheme given in table. Here it is 30 months. So, my lord, even if we hold that, my lord, he will have to be promoted from 2023 when the DPC was held. Then also, my lord, it will be 2028, he will complete the 5 years. Or to be eligible for promotion to the post of professor. Because DPC was held in 2023 after 2020.
No, his 5 years of teaching experience is there as a reader.
As a reader.
So he was supposed to have been promoted as a reader, or he obtained the qualifications as a reader.
April 2021.
2021. He was promoted.
He was promoted. No, my lord, DPC was held in 2020. Then he was a lecturer. Now, my lord, he was promoted to the post of reader in 2024. Pursuant to the DPC held in 2023. After 2020, the DPC was held in 2023. By the time he is acquired in 2021, he acquired the, my lord, points, 20 points. So even if it is held at, my lord, his reader will have to be, my lord, counted from 2023. Then also, my lord, he becomes eligible with that 5 years. Apart from that, my lord, points in 2028. That is my instruction. I got the parawage in the first case. On Saturday, I got the.
So you were promoted in the post of a reader in the year 24.
My lord, yes, correct. That is under challenge, my lord. In the likewise same case, my lord, as that of the other case, she was also promoted belatedly. That promotion was challenged, and your lordship said that had it been, my lord, given a retrospective effect or antedated, my lord, by the time she would have, my lord, been eligible. That was not done in my in my case also, my lord. In 21, I had been, my lord, rendered eligible. My lord, this is the order. My lord, this order will make it clear. While issuing notice, your lordship will pass this order in the other case. Similar, identical
case. Is it
case,
not enclosed?
My lord, I have enclosed the interim order passed by your lordship, but this is the order while issuing notice, my lord. Here the facts are very clear. 1 page order, my lord. Delayed promotion to the post of reader in the regional dental college.
In your case, where is the direction to be given?
Yes.
With effect?
In respect of the lecturer, my lord.
Yes.
That order I have already drawn your lordship's attention, my lord. High Court's order. It's, my lord, page 66.
Of which petition?
My lord, it's 7857/22.
No, in where is it enclosed?
My lord, it is enclosed in the first writ petition, my lord, 3206.
3206.
Yes.
Okay, where is that? Page number?
Page, my lord, starts from 66, my lord.
66.
Yes, and para 3, my lord, this, if your lordship comes to para 3, the facts, my lord, is recorded. Page 68, my lord. The petitioner, after obtaining the MDS degree, made a representation dated 17/8/27 to the Commissioner and Secretary Health, requesting for upgradation of the post of tutor to lecturer in so-and-so department under Mogor University, Patna in the year 2017. Consequent thereto, the petitioner by notification dated 23/2/21 was promoted as lecturer Gauhati for the post of tutor RDC Gauhati. Now, my lord, the relevant part, page 69, para 6, my lord.
Yes.
In that view of the matter, the respondents are directed to redesignate the post of tutor held by the petitioner as lecturer with effect from so-and-so, 16/8/2017.
This writ petition, the present writ petitioner was also a party. Okay, that is his writ petition.
Yeah, his writ petition. Yeah, his writ petition. In my case also, this order is there. So, my lord, my counting, my lord, as a lecturer has to be from the date of acquisition of the MDS. I acquired in May 2017 and joined on 15/6/2017. So, counting 4 years as lecturer in terms of the High Court's order, I acquired the eligibility, my lord, to be promoted to the post of reader in terms, my lord, having the qualification of 4 years, teaching experience of 4 years. That is, my lord, 15/6/21.
No. Your claim is that the day you acquire MDS, your post should have been designated as a lecturer.
That has been directed, my lord.
That has been directed.
Yes.
So that direction, according to the court, it ought to have been done on 16/8/2017.
Yes.
Now, had it been done, or if that is done, then you acquire the eligibility for being promoted to the post of a reader.
Yes. In 21 itself.
21 itself.
Yes. Now, counting from 21, in 26, my lord, May, my lord, have the experience of 5 years as a reader, which is, my lord, the qualification for the post of.
Now you come to para 8 of the said order.
My lord. 8.
Para 8.
Yes. As regards promotion to the post of reader, this court is of the considered opinion that the DPC is the appropriate authority to consider the case of the petitioner for promotion to the post of reader. Accordingly, as and when the DPC is held for promotion to the post of reader, it is directed that the case of the petitioner should be considered, considering the fact that the post of tutor being held by the petitioner has already been redesignated with effect as lecturer with effect from so and so. So, counting from 2017, my lord, I have 4 years experience as lecturer, and I acquired, while I meet the eligibility criteria to be promoted to the post of reader, because 4 years, my lord, lecturer is necessary in 2021. So now your lordship will see the order of reader, my lord, the impugn order is passed at page 70 only in 24. Whereas, my lord, it ought to have been passed in 21.
That is the direction to be issued to the DPC or the authorities. That is why I refer to para 8.
Yeah.
Para 8, there is no direction. Right. See, if in the rules, in some rules it is there in respect of some services, that you are eligible to the post of a, let us say, post of a professor, if you put in 4 years as a reader or 8 years as a lecturer. Right? So, notwithstanding that you are not promoted within this stipulated time as a reader, had the requirement been that the service rendered by you as a lecturer for 8 years or 9 years or 10 years, whatever the requirement may be, if it was available under the rules, then you have a claim that now, see, I've notwithstanding my promotion being the post of a reader belatedly, I have meanwhile completed the required services as a lecturer. Therefore, my case should have been considered for the post of a promotion, but the rules don't say so.
Correct.
The rules are very compartmental.
Correct. Correct.
Lecturer to reader,
correct.
reader to professor.
Correct.
So now you, having acquired the eligibility to be a lecturer, the court ordering this, the consequential order perhaps was not there, that you should now immediately be considered by the DPC for being
No,
promoted to
that
the
I,
post of-
that I concede, my lord.
Right.
What I'm on.
So
Yeah,
now
Lordship is
your
correct,
claim
correct.
is that this belated consideration by the reader
Right.
now has to be antedated.
Correct, my lord.
Right?
Correct, correct. That is my case, absolutely.
So
And I am,
until that is done,
Yeah.
or until prima facie there is a view that you are entitled to under the law, the interim direction to send your papers for the consideration will have no effect.
my lord, Lordship will kindly see, precisely that was the case. But while issuing notice, your Lordship had passed this order. I'm just reading it out. The, my lord, order which I have handed over. It is the submission of the petitioner that there is already an order of this court directing that the seniority of the writ petitioner to the post in the post of lecturer is with the effect from so and so.
Where is this order?
My
Where
lord.
is this order? Which was earlier given in the case of Dr.
Regarding lecturer, man. Regarding lecturer.
No.
Sulekha Dole regarding lecturer.
Ah.
Yes, that order is part. Yes. I have next year, my lord. Your Lordship will come to that order. It starts from, my lord, page 61, my lord, 4475/20. And the relevant part, I take your Lordships to page 67. No.
67.
Yes, 67, para 16, man. Lordship has got it. The
No,
letter,
but this is your writ petition.
my writ petition.
I'm talking about the writ petition filed by Dr. Dole.
Dr. Dole, this is order passed in Dr. Dole's, my lord, case.
No, this is in your case, 67.
No.
67
my lord,
in the 3206.
this is not the other case, my lord. The other case.
3274 2026.
The order,
67.
yes, the order starts from page 61, my lord.
Right.
I'm referring to page 67, my lord, para 16. The letter dated so-and-so issued by Principal RDC Gauhati, which is addressed to the Director so-and-so, states that 7 numbers of tutor, of which 4 teachers are MDS qualified, including the petitioner, are to be redesignated as lecturers as they have obtained their MDS degree during the service period. The contents of the above letter dated so-and-so also shows that the state respondents have interpreted the contents of the notification dated 31/10/21 to mean that the tutor is to be redesignated as lecturer and not promoted. In this respect, though the request for redesignation has been made by letter dated so-and-so by the Principal RDC Gauhati, this court is of the opinion that redesignation would automatically have to take place from the date when the tutor acquires MDS degree in terms of the notification dated so-and-so. As the petitioner has rejoined the post of tutor on Iman after obtaining the MDS degree, this court holds that the petitioner's redesignation as tutor has to be redesignated as lecturer with effect from so-and-so, as the petitioner has become eligible for the higher AGP of so-and-so. And pursuant to this particular order has been, my lord, referred by your Lordships, my lord, in this order of 23/3/26. Our redesignation was also belated. So she approached this court, and the Honorable Court directed that the redesignation has to be from the date of acquisition of the MDS degree, as that of my case.
Para 17 Lordship page 67 of the Dole's case. Para 17. Already rejected for the post of leader. So that has been put to challenge in the new writ petition when the order was passed.
What benefit do you get? What benefit do you get?
Prima facie, my lord, no.
You don't get any benefit by your papers being placed because you're foreigners. Admittedly, you're not qualified 5 years.
No, that order of 24 related, my lord, promotion to the reader, that I have challenged, man. That part your Lordship will consider.
No, that you challenge.
Yeah.
That you challenge, and you get an order from the court where your promotion is antedated. then consequential direction for a review DPC can always be issued. But at this stage, to have your papers placed before the DPC, when prima facie you are unable to satisfy the court that you have completed 5 years, what benefit?
That
do you
I
get?
admit, my lord, I have not completed.
Then
But that order, my lord, is order passing in 24. That is under challenge.
that is under challenge, but no order has been passed.
No order has been passed, my lord.
There is no interim direction that your services should be treated to be that of a reader with effect from so and so date. There is no
Correct, my
order.
lord. But I, my lord, stand on a similar footing as that of the
All
other.
right, let us assume that you stand on a similar footing. What benefit do you get by placing it before the DPC scheduled to be held for the professor? What
My lord,
benefit?
that will be subject to outcome of my writ petition, my lord.
Which writ petition?
Of the subsequent challenge, my lord, of my belated promotion.
That's what we are trying to make you understand
My
in the
lord,
past.
if
few
I,
days.
my lord, succeed,
Then
then
assuming you succeed, there
Yes,
can be a consequential direction
That-
to hold
that-
the review DPC,
that I leave it to Lord.
irrespective of this particular DPC,
Yes.
and to consider your case for promotion to the post of professor with effect from the day
Correct.
when your
That
juniors
will
are
be done. But
present.
since the DPC is being held now,
Then
my lord.
DPC is being
Yes.
held, but your papers will not be open because prima facie you don't satisfy 5 years. So what benefit do you
That I
get?
understand, my lord. I don't satisfy that because
Then
of
what
the
benefit do you
belated
get?
order. But
Let
I
us assume that an interim order was passed in this matter. We accept what the council say. We have passed an order.
That I leave it to
The state respondent also said that order can be passed.
That I leave it to your lordship, my lord.
Was for another writ petition, my lord, because it will be rejected by the apparently by the DPC. Again, my lord, fresh cause of action. We'll have
That
to
I
be
leave it to
challenged,
your
my lord,
lordship.
again.
That I leave it.
Yeah, prima facie, I don't see how you're prejudiced. It's not about giving you or not giving an order.
Because, my lord, the prejudice is because the post is lying vacant. There are 2 posts, my lord. Your lordship also asked me, my lord.
We have understood
It's not a case, my
everything,
lord.
but the rules are very categorical.
Yes.
5 years as a reader. If it is 10 years or 8 years as a lecturer, then perhaps
Yes.
there was an alternative route for you to be included.
Yes. Yeah.
But the route is 5 years.
That is
And you don't, admittedly, you don't complete 5 years unless your promotion is antedated. And for a promotion to be antedated, you file a writ petition which will require.
Yes.
hearing
That
in the matter.
adjudication would be required.
Once that benefit is granted,
Then I leave it to your lordship. But I was asking for a similar order as passed by in the other case. Only that much, man. Since your
I
lordship has
also
already
repeat, your
passed.
lords, prima facie, my lord, ultimately it will be rejected as on that, on the face of it appears. Because 5 years is not there. On top of that, there will have to be publication point of 30.
which writ petition are you challenging the antedated?
The other one, which is listed item number
3274.
Yes, well. Item 19.
Item 19.
19.
This is the first day the matter has come. There is no
No, this yes, first day. Body satisfaction, my lord. Similar candidate.
satisfaction.
That afterwards, your lordship will decide my writ petition, my lord. That's a different aspect.
Mr. Gogoi, we have asked him to keep it in seal cover, is it?
Correct, correct.
In the other case,
Yeah,
here. Only of the petitioner to be kept in seal cover. Otherwise, we have given
Consider
the
his case, he says it is on the same footing, because otherwise also no advantage will be given to
Yes.
him. Heard counsel for the party. This is an item number 57. We are passing this order considering the vacations are round the corner.
I'm obliged by
But only thing, my lord, we will be at liberty to proceed, my lord, if he is not eligible.
Huh?
We will be at liberty to proceed with the promotion, my lord, DPC meeting and to give effect to the
Very
promotion.
clear that
Yes.
it should be put in
2
seal
posts, my
cover.
lord, 2 candidates. No problem.
Was it directed to be kept in a seal cover?
Yes, only of the petitioner.
Oh.
The other.
Third learning council for the petitioner. By order dated 17/6/2026. The matter was heard at some length, notices were issued. However, the matter was fixed today for consideration of the interim prayer. Where Mr. Talukdar, referring to an order passed by this court dated 23/3/2026 in WPC 1675/2026, submits that in the writ petition, in the said writ petition filed by a similarly situated person, there was an interim direction by the court directing the respondent authorities to forward the necessary papers of the incumbent to be placed before the DPC for consideration. And where is that order we have passed?
Page 96, my lord, of the writ petition 3206.
It's passed in 8/6/26 in IA number 1841 of 2026 and connected to WPC number 1675 of 2026. So, stop. It is whereby the papers were directed to be placed with the DPC for which is to be constituted for selection and promotion to the post of professor, pedodontics and preventive dentistry in the Regional Dental College, Gauhati. However, the recommendations in respect of that applicant writ petition were to be kept under seal cover. Be open upon such orders as may be passed in the accompanying writ petition filed by the said petitioner. Counsel for the petitioner in the present proceedings prays for similar protection in the interim. So, it is projected by the counsel for the petitioner that the present writ petitioner and the writ petitioner in WPC 1675 of 2026 are similarly situated. Both were both are serving as readers in the department of so and so. Same department.
Look, she's different. I'm different, man.
Okay.
I'm oral pathology, microbiology.
Reader in the Regional Dental College, and it is their prayer before the court, it's their claim before the court that because of non-consideration of their cases for promotion to the post of reader at the relevant point in time, they were belatedly promoted, and as a consequence thereof, they do not meet the eligibility criteria for promotion to the post of professor. So, however, insofar as WPC 1675 of 2026, the petitioner, it was stated before the court that there is an order already in favor of the writ petitioner directing the respondent authorities to grant antedated promotion to the post of reader, which was not carried out.
Post of lecturer.
Post of
Lecturer.
Lecturer.
Yes.
Lecturer, which was not carried out, and therefore her claim is before the authorities for antedating her promotion to reader. So, similar prayers are made by the present writ petitioner, present proceedings. So, considering Mr. Bowai, additional AG appearing for the state, on the other hand, submits that the rules are very clear. The eligibility criteria is 5 years of services rendered as a reader.
As well as, my lord, points of 30 marks on publication.
And requiring points of 30 marks on necessary publications.
Journals.
In the journals. Stop. The present petitioner was promoted to the post of a reader in
2024.
2024. And what about his points?
Points, my lord, that I don't have the inspection. I will have it, my lord, in the meeting.
Therefore, under the rules, he does not satisfy the requirement of 5 years. Therefore, his case was not considered.
This order is
Not eligible, my lord.
Not eligible to be considered.
Yes, so to the post of professor.
This order is under challenge.
Mr. Talukdar, on the other hand, submits that the order of promotion to the post of reader issued in the year 2024 is the subject matter of WPC number 3274 of 2026, wherein the petitioner seeks a direction for antedated promotion from the post of reader. In that view of the matter, he submits that in the event his prayer in writ petition 3274 is granted, then the petitioner's promotion will be antedated with effect from 21. And he will thereby acquire the eligibility for rendering services
As reader.
as a reader
To the post of professor.
for making himself eligible to the post of professor. So, in such circumstances, it is submitted that an order passed by the court in WPC 1 in IA number 70 be issued also in favor of the writ petitioner in the interim. Considering the submissions, let the papers of the writ petitioner also be placed before the ensuing DPC to be scheduled to be held for the post of Professor Pedodontics and Preventive Dentistry in the Regional Dental College. This is the post of Professor or something else?
It's oral pathology, microbiology, and forensic odontology.
Is there a post available?
Yes, two posts.
That's why DPC.
Okay, Professor, what is that?
Oral pathology,
Oral pathology,
microbiology, and
microbiology and
forensic odontology.
forensic odontology, Regional Dental College, Gauhati. So, the findings of the DPC, however, all relevant papers, including ACR, we placed before the DPC. Respect of the writ petitioner. So, however, the findings of the DPC will be kept in sealed cover, which will be open, be subject to orders of this court.
By finding of the DPC in respect of the
In respect of the writ petition. Let this matter be listed after 3 weeks. And after 4 weeks. And in WPC 3274, we issue notice. Issue notice returnable 4 weeks. Mr. B. Dubois, additional lady, appears for all the response. Therefore, notices are waived, extra copy is furnished.